A new development in the Charles Adelson appeal from his convictions for the murder of Dan Markel, his former brother-in-law, who was killed by two hitmen from Miami.
Hello, everybody. My name is Emma. Let's get started.
Very serious.
In the end of November, Charles's lawyers asked the appellate court to hold oral argument in the appeal. Most appeals are decided without oral argument. A request for oral argument does not guarantee that the court will hold oral argument. The fact that the court granted oral argument does have some meaning. It means that the court does think that oral argument would not be a waste, that there are interesting issues to discuss. It does not mean, however, that the court will reverse or will affirm, or that the court agrees that the party who requested oral argument has a better chance of winning. In fact, even if only one judge on the panel wants oral argument, then oral argument will be held. It is not surprising that oral argument was granted in this case, given the complexity and number of issues raised and the fact that this was a murder conviction with a life sentence following a relatively long trial. Here is what Charles' lawyers wrote when requesting oral argument. Quote, "This appeal concerns significant constitutional issues, challenging whether the proceedings below preserved appellant Adelson's right to a fair trial before an impartial jury and to the fair and complete presentation of a defense. Appellant Adelson respectfully submits that oral argument will assist the court in its consideration of these issues and enhance the court's understanding of the arguments presented," unquote. The court has set this case for oral argument at 10 a.m. on Tuesday, February 3, 2026. The argument is scheduled before Judges Rowe, Winokur, and M.K. Thomas, but the panel is subject to change. The court has allotted 20 minutes per side, which is longer than the time allotted for most oral arguments, but that is not surprising given the multitude of issues raised and the nature of the case. Let me tell you a little bit about the judges. By the way, Mentor Lawyer has had cases in front of all of them. Here we go. Judge Lori S. Rowe is a former chief judge of the First District Court of Appeal. She became an appellate judge in 2009. Mentor Lawyer has handled multiple oral arguments in front of her. She's a 1997 graduate of the Florida State University College of Law. Judge Thomas D. Winokur was appointed to the First District Court of Appeal in 2015. Before his appointment, Judge Winokur had served as Assistant General Counsel for the Executive Office of the Governor since 2011. He previously served as Assistant Attorney General for the Florida Office of Attorney General, practicing in criminal appeals and capital litigation. He attended law school at the University of Florida. Finally, we have Judge M. Kemmerly Thomas. She was appointed to the First District Court of Appeal on June 2, 2016 by Governor Rick Scott and took office on June 20th, 2016. Prior to her appointment to the First District Court of Appeal, Judge Thomas was in private practice in Tallahassee, Florida, as well as Thomasville and Savannah, Georgia, from 1991 to 2016. She practiced in the areas of workers' compensation defense, employment issues, lien resolution, and carrier audit litigation. Judge Thomas received her Juris Doctor from the University of Mississippi College of Law in 1991. Judge Thomas was a former court-appointed member of the Second Judicial Circuit Professionalism and Ethics Committee, a member of the State of Florida Workers' Compensation Section, a member of the State of Georgia Workers' Compensation Section. She's also a certified wildlife conservation and land management expert. In 2017, Judge Thomas was inducted into the Florida Workers' Compensation Institute Hall of Fame. All three are excellent judges, of course. We will cover the oral argument here on Deep Dive True Crime. Now, if you want to prepare for oral argument, like the judges will, you can watch the rest of this video. Here, we combined my readings of the initial brief, the answer brief, and the reply brief. I'm Ed, not AI. Here is the rest of the video.
Hi everyone, my name is Maya with Deep Dive True Crime. In this video, we will give you the 84-page initial brief that was finally filed in Charles Adelson's appeal by his appellate lawyers, Michael Ufferman and Laurel Niles. Incredibly, our own Ed from the Ed Talk Show will read for all of us the entire brief. But first, let me assure you, Ed is not AI. I can assure you of that. He's a real guy. I've seen him, and I'll give you my word. He's not AI, neither am I. Alright, now let's get into the brief. And remember, Ed is not AI, although he may sound like it. Again, I'm Maya with Deep Dive True Crime and Mentor Lawyer Justice Network.
Okay, let's read the 91-page appeal by Charlie Adelson, titled Charles Adelson, Appellant v. State of Florida Appellee, case number 1D24-0004, Direct Criminal Appeal, 2nd Circuit, Leon County, LT number 2016-CF-3036, initial brief of appellant. In it, Adelson makes 5 arguments. 1. The trial court erred when by denying appellant Adelson's motion for a change of venue. 2. The trial court abused its discretion when it denied appellant Adelson's motion to strike the venire panel after several potential jurors reported to the court and the parties that other potential jurors were having conversations together about the case after being instructed not to do so. 3. The trial court erred by precluding the defense from entering text messages that would have shown that appellant Adelson and other alleged co-conspirators were communicating normally during the time leading up to Dan Markel's murder to rebut the state's contention that appellant Adelson and the alleged co-conspirators were making phone calls about the murder during the time in question. 4. The trial court improperly excluded relevant, accepted hearsay evidence that was highly probative to the theory of defense, i.e., a recorded phone call where appellant Adelson made the statement that he had been extorted in the past, and this is not how extortion works. And 5, cumulative error. We'll go over each argument in detail. I'll also call out each page number. In the interest of time, I'll not read the table of contents, the table of citations, the certificate of service, or the certificate of compliance. Let's get started. Page 1. C. Statement of the case and statement of the facts. 1. Statement of the case and course of proceedings below. Charlie Adelson, hereinafter appellant Adelson, was charged in April of 2022 with first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder for the 2014 killing of Dan Markel. Dan Markel was shot in Leon County on July 18, 2014, and he died on July 19, 2014. 3 people were already serving prison sentences for the murder of Dan Markel at the time of appellant Adelson's trial. Luis Rivera, no contest plea. Sigfredo Garcia, found guilty at trial in 2019, and Catherine Magbanua, found guilty at trial in 2022 after a hung jury mistrial in 2019. At trial, appellant Adelson was represented by Daniel L. Rashbaum, Esquire, page 2. Footnote. For all the reasons set forth in the motion filed in this court on October 16, 2024, undersigned counsel continue to assert that Mr. Rashbaum had a conflict of interest that infected appellant Adelson's trial, and if necessary, appellant Adelson reserves the right to raise this conflict claim in a post-conviction motion. And Catherine Myers, Esquire. The state was represented by Assistant State Attorneys Sarah Catherine Dugan and Georgia Kappelman. The Honorable Stephen Everett presided over the trial. The trial began on October 23, 2023, and concluded on November 6, 2023. At the conclusion of the trial, the jury found appellant Adelson guilty as charged on all counts. The sentencing hearing was held on December 12, 2023. The trial court sentenced appellant Adelson to life in prison on the murder count, followed by 30 years imprisonment on the other 2 counts. 2. Statement of the facts. A. The state's case in chief. The state of Florida alleged that appellant Adelson orchestrated the murder of Dan Markel, page 3, a Florida State University professor, due to a bitter child custody dispute between Markel and appellant Adelson's sister, Wendy Adelson. The state claimed that appellant Adelson hired hitman Sigfredo Garcia and Luis Rivera, although Catherine Katie Magbanua, who was appellant Adelson's then-girlfriend. During opening statements, evidence previewed by the prosecution included wiretaps, financial transactions, and a money trail, and Wendy Adelson's actions post-murder, i.e., relocating to South Florida very quickly and changing the children's last name. Appellant Adelson's defense disputed this interpretation, explaining that appellant Adelson had not been involved in planning the murder, but had been extorted by the killers, Magbanua, Garcia, and Rivera, after the fact. Dan Markel was shot twice in the head on July 18, 2014, while in his vehicle in his garage on Trescott Drive in Tallahassee, Florida. Dan Markel and Wendy Adelson had been divorced, and even after the divorce was finalized in July 2013, continued to have legal disputes regarding parenting, time-sharing, page 4, financial and other issues. One of the issues involved Wendy Adelson's wish to relocate from Tallahassee to South Florida with her and Dan Markel's 2 children. Wendy Adelson's request to relocate was denied by the court. Emails between Wendy Adelson and her mother, Donna Adelson, indicated a continued desire, at least on the part of Donna, for Wendy and the children to relocate. An email from Donna suggested that Wendy should offer Dan Markel $1 million to allow her to move to South Florida with the children. Donna's email suggested that the payment would be funded by Wendy's parents, i.e. Donna and Harvey Adelson, Wendy, and appellant Adelson. On the morning of Dan Markel's murder, Markel dropped off his and Wendy's children at preschool and then went to the gym. Surveillance from the gym, city buses, and other locations showed a vehicle, a light green Prius, following Markel around town that morning. Based on distinctive features of the vehicle, a SunPass transponder, and cell phone analysis, investigators, page 5, developed a suspect vehicle and traced it to South Florida. The vehicle was rented by Luis Rivera. Sigfredo Garcia's phone number was also on the rental agreement. Sigfredo Garcia and Luis Rivera were known by the nicknames Tuto and Tato, respectively. Magbanua was romantically linked to Garcia, and they shared children. The Adelson Institute was a family-owned dental practice owned by Harvey Adelson and appellant Adelson. Starting September 2014, Magbanua began receiving payments from the Adelson Institute, despite no evidence that she performed work duties there. The checks were in batches, meaning sequentially numbered, even though they were dated weeks apart. There were 18 sequential checks made out to Magbanua. Donna Adelson, who managed the dental practice, signed the checks made out to Magbanua. On the day Dan Markel was shot, Wendy Adelson told police that it was possible that her family could have been responsible. Appellant Adelson bought Wendy Adelson a television as a divorce present. He joked that he had looked into hiring a hitman, page 6, but the television was cheaper. On the morning of the shooting, the television that appellant Adelson had bought Wendy Adelson was being repaired at her home, while Wendy Adelson was present. There was a calendar event in Wendy Adelson's phone call called Fix TV on the morning of Dan Markel's shooting. Magbanua and appellant Adelson had dated. When Magbanua was arrested for the murder of Dan Markel in 2016, appellant Adelson became stressed. Donna Adelson also appeared stressed and upset about this time. Appellant Adelson was implicated in the probable cause affidavit for Magbanua. Appellant Adelson was known to staple his money together in bundles. Jeffrey Lacasse, who was dating Wendy Adelson around the time of the murder, testified that on July 13, 2014, Wendy Adelson told him in a serious tone and in confidence that appellant Adelson had actually looked into hiring a hitman to kill Markel. Wendy Adelson, who was called as a witness for the state, denied ever saying that to Lacasse. Wendy Adelson and Lacasse, page 7, broke up about a week before Dan Markel was killed. Lacasse was excluded as a suspect in the murder of Dan Markel because he was out of town on the day Markel was shot. At some point in July of 2014, appellant Adelson was nearly run off the road by Sigfredo Garcia. Garcia was angry about Magbanawah's relationship with appellant Adelson. Garcia blocked the road and yelled at appellant Adelson and Magbanawah in their vehicle. Garcia hated appellant Adelson. Luis Rivera was the head of the Latin Kings gang in North Miami Beach. He testified as a state's witness in all of the prosecutions for Dan Markel's murder in exchange for a 19-year prison sentence, which would be served concurrent to a federal sentence he was already serving. Rivera became involved in the murder of Dan Markel through a friend, Sigfredo Garcia. Garcia came to know about this job to do the murder through Garcia's girlfriend, Magbanawah. Magbanawah hired Garcia, and Garcia hired Rivera. Magbanawah has to get the money after the murder was done. According to Rivera, page 8, Magbanawah got the money from, quote, the dentists, unquote. The money was split 3 ways, with Rivera getting $37,000. Rivera and Garcia came to Tallahassee once in July 2014 to commit the murder, but they lost track of Dan Markel while following him. When they came to Tallahassee, they had a piece of paper with a photo of Dan Markel and his address. During the subsequent July trip to Tallahassee, Rivera and Garcia learned through Magbanawah that Dan Markel was leaving town the next day. All of Garcia's knowledge came from Magbanawah, and anything Garcia and Rivera did in connection with the murder had to be cleared through Magbanawah. Magbanawah told Garcia that she would get back together with him if he did the murder for her. When they arrived at Markel's house, Rivera pulled the green Prius behind Markel's vehicle in the driveway, and Garcia got out and shot Markel twice. Garcia called Magbanawah after the murder. Magbanawah told Garcia, "You'll get the money tomorrow." The next day, Rivera got $35,000 from Magbanawah, page 9, in $100 bills, stapled together in bundles of $1,000. Garcia gave him $2,000 extra. Katie Magbanawah was a state's witness. She was convicted of the murder of Dan Markel, and she testified in her own defense in each of her 2 trials and claimed not to be involved in the murder, conspiracy, or solicitation. She also testified at Sigfredo Garcia's trial that Garcia had nothing to do with the murder. Pretty soon after Magbanawah was arrested, she was offered to cooperate against appellant Adelson in exchange for full immunity or a get-out-of-jail-free card. She did not accept the offer. In appellant Adelson's trial, Magbanawah testified that appellant Adelson came up with the idea to kill Dan Markel sometime around Halloween of 2013. By that time, appellant Adelson and Magbanawah had been dating about 2 weeks. According to Magbanawah, although appellant Adelson solicited Magbanawah to find someone to kill Markel, he did not know it was her child's father, Garcia, that she had enlisted. Likewise, Garcia did not know that he was doing the murder to help out appellant Adelson, page 10. Magbanawah provided Garcia and Rivera with money for expenses for the trips to Tallahassee. Magbanawah got the money for the murder from appellant Adelson the morning after the murder. The money was stapled. According to Magbanawah's trial testimony, the money was moldy, and she believed it had been physically washed by Donna Adelson, given that appellant Adelson had never had money in his house, and she believed that appellant Adelson's parents had stopped by the house before she got there. Magbanawah took the money and paid Rivera and Garcia. After the murder, Rivera bought a motorcycle and Garcia bought 3 cars. Magbanawah acquired a Lexus that was previously owned by Harvey Adelson. Magbanawah received $2,000 a month from the Adelson Institute beginning in October 2014. The state introduced call records to show incoming and outgoing calls between appellant Adelson and Magbanawah, and Magbanawah and Garcia, and appellant Adelson and his parents' home, page 11, during the time frame of the significant events in this case. According to state's expert, Sergeant Chris Corbett, The phone call records showed the physical acts of the co-conspirators because they occurred during the car rental, the trips to Tallahassee, and the return after the murder of Markel. Additionally, call turnaround, meaning one of the co-conspirators ended a phone call with one co-conspirator and then immediately called another co-conspirator, stood out to investigators. For example, the expert testified that Magbanua talked to Appellant Adelson on the phone for 25 minutes after dropping off Garcia at the rental car agency. Then, after the call with Magbanua ended, Appellant Adelson called his parents' landline. Another example is that during the June trip that Rivera and Garcia made to Tallahassee, from June 2 to June 5, Appellant Adelson contacted Magbanua 10 times. Magbanua contacted Garcia 12 times. Magbanua contacted Appellant Adelson 7 times, and Appellant Adelson contacted Donna Adelson 5 times. On the morning of Dan Markel's murder, there were phone calls from Appellant Adelson to Wendy Adelson, page 12, Appellant Adelson to Donna Adelson, and Appellant Adelson to Magbanua. After the murder, during which Rivera and Garcia's phones were possibly turned off, the first call that Garcia made was to Magbanua. Investigators secured a wiretap in 2016 to listen to the calls made between the alleged co-conspirators in real time. Appellant Adelson's and Magbanua's phones were among the lines tapped. On April 19, 2016, Donna Adelson was approached in the street by an undercover officer and handed a piece of paper with an article about Dan Markel's murder. This operation was known during the trial as the Bump. During the Bump, an FBI agent portrayed a Latin Kings gang member who wanted money for his continued silence about Dan Markel's murder. The interaction was video and audio recorded and played to the jury. Donna Adelson's first call after the Bump was to Appellant Adelson. Later, the undercover FBI agent portraying the same character made a phone call to the dental practice, page 13, on April 28, 2016. After the Bump, Appellant Adelson called Magbanua and gave her the phone number from the paper that the undercover FBI agent had given Donna Adelson. Magbanua never called the number, but told Appellant Adelson that she did. Magbanua actually told Garcia to call the number. On April 28, 2016, Appellant Adelson called the number and spoke to the undercover agent. The Adelsons did not pay the money that the FBI agent had solicited from Donna Adelson. An in-person conversation between Appellant Adelson and Magbanua was recorded by the FBI at a restaurant north of Miami Beach. A forensic engineer processed and enhanced the recording from that restaurant, and one other recording of Appellant Adelson with Harvey Adelson in a different restaurant. Other phone calls between Appellant Adelson and Donna Adelson that were obtained from the wiretap were published to the jury. B. Appellant Adelson's case in chief. Appellant Adelson testified in his defense. He, page 14, asserted that he had nothing to do with Dan Markel's murder and that he found out that the murder was done by a friend of Magbanua's on the night after it was committed. Magbanua told Appellant Adelson that if he did not pay the killers through Magbanua, he would be killed. Appellant Adelson told Magbanua that he felt like he was being extorted, and Magbanua became angry and said she was not trying to extort him, she was trying to help him. Magbanua said the murder was her fault because she talked about the cash offer that the Adelsons were going to make to Dan Markel to allow Wendy Adelson and the children to relocate. Magbanua took $138,000 in cash out of Appellant Adelson's safe. Magbanua asked if Appellant Adelson could make monthly payments towards the rest of $250,000, and Appellant Adelson agreed. Magbanua called her friend about the arrangement, who indicated that payments of $3,000 a month could be made, but those payments would not offset the balance owed. Appellant Adelson believed that Magbanua was not part of the extortion plot, and, page 15, that she did not know the murder would happen. Aside from Wendy Adelson's divorce attorney, no other defense witnesses were called. Footnote: Donna and Harvey Adelson were removed as defense witnesses by defense counsel after they were ordered by the trial court to appear for an interview by the FBI on October 12, 2023. Page 16. D. Summary of argument. Appellant Adelson raises 5 claims on appeal. First, the trial court erred when, by denying Appellant Adelson's motion for a change of venue, during the jury selection process, after attempting to select a jury, it became clear that it was not possible to convene a fair and impartial jury because of the extensive pretrial publicity, i.e., because the Tallahassee community was, quote, so pervasively exposed to the circumstances of the incident that prejudice, bias, and preconceived opinions were the natural result. Manning v. State. Notably, prior to jury selection, 54 potential jurors had already formulated an opinion about the guilt or innocence of Appellant Adelson, and 53 of them believed that Appellant Adelson is guilty. Second, the trial court abused its discretion when it denied Appellant Adelson's motion to strike the venire panel after several potential jurors reported to the court and the parties that other potential jurors were having conversations together about the case after being instructed not to do so. In fact, there were multiple accounts, page 17, of potential jurors talking about the case, and some of the jurors who had been discussing the case were the same jurors who held a preconceived belief that Appellant Adelson is guilty, and some of the comments that were reported were expressions of Appellant Adelson's guilt. Therefore, the trial court's refusal to strike the jury venire was unreasonable based on the record in this case. Third, the trial court erred by precluding the defense from entering text messages that would have shown that Appellant Adelson and his alleged co-conspirators were communicating normally during the time of the first attempt on Dan Markel's life, to rebut the state's contention that Appellant Adelson and the alleged co-conspirators were making phone calls about the murder during the time in question. The excluded text messages tended to establish a reasonable doubt as to Appellant Adelson's guilt. The state was permitted to show the jury that phone calls occurred between the alleged co-conspirators and to argue that the fact that the alleged co-conspirators were communicating on certain dates showed that they were conspiring about or at least discussing the murder. Page 18. The defense wanted to show the actual substance of the text messages to the jury to negate the state's assertion that these alleged co-conspirators were discussing the murder and that the substance of the messages was in fact not about the murder but were about normal things. Fourth, the trial court improperly excluded relevant, accepted hearsay evidence that was highly probative to the theory of defense, i.e., a recorded phone call where Appellant Adelson made the statement that he had been extorted in the past, and this is not how extortion works. The statement of Appellant Adelson that this is not how extortion is done was not being offered to prove the truth of the matter asserted, that is, that extortion is not done in the particular way the FBI was doing it. Rather, the statement was to be used to show that Appellant Adelson believed that the police were behind the bump extortion because he had been previously extorted by Dan Markel's killers. Finally, the cumulative effect of the errors in this case denied Appellant Adelson a fair and impartial trial.
That concludes part 1 of the initial brief, which included the statement of facts and summary of the argument. Hi everyone, my name is Maya with Deep Dive True Crime and Mentor Lawyer Justice Network, and I am back with part 2 of Charles Adelson's initial brief. In this video, Ed will continue to read from pages 19 to 51, and this will include the entirety of argument 1. Now, I'll pass it on to our very professional speaker, Ed.
Page 19. E. Argument and citations of authority. 1. The trial court erred when by denying Appellant Adelson's motion for a change of venue. A. Standard of review. A trial court's ruling denying a motion for a change of venue is reviewed on appeal pursuant to the abuse of discretion standard of review. See State v. Knight. B. Argument. During the jury selection process, after attempting to select a jury, it became clear that it was not possible to convene a fair and impartial jury because of the extensive pretrial publicity, i.e., because the Tallahassee community was, quote, so pervasively exposed to the circumstances of the incident that prejudice, bias, and preconceived opinions were the natural result. Manning v. State. Both the Florida Constitution and the United States Constitution protect the defendant's right to a fair trial by an impartial jury, see U.S. Constitution. The Constitution safeguards the defendant's venue right, page 20, as explained by the Florida Supreme Court in Rawling v. State, quoting, "It is a well-settled principle under our case law that a criminal trial may be held in a county other than that designated by the Constitution or by statute if prejudice in the proper county makes it impossible for a defendant to secure a fair trial by an impartial jury there. Such prejudice may warrant a change of venue when widespread public knowledge of the case in the proper county causes prospective jurors there to judge the defendant with great disfavor because of his character or the nature of the alleged offense. When this occurs, the defendant's right under the United States and Florida Constitutions to a fair trial by an impartial jury is protected by moving the trial from the proper but partial county to an impartial one. A trial judge is bound to grant a motion for a change of venue when the evidence presented reflects that the community is so pervasively exposed to the circumstances of the incident that prejudice, bias, and preconceived opinions are the natural result. See Manning. In McCaskill v. State, the Florida Supreme Court announced the test for determining whether a change of venue is required because of prejudice in the proper county. The test for determining a change of venue is whether the, page 21, general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely upon the evidence presented in the courtroom. Quoting Kelly v. State, "In exercising its discretion, a trial court must make a two-pronged analysis evaluating 1, the extent and nature of any pretrial publicity, and 2, the difficulty encountered in actually selecting a jury. See Murphy v. Florida. On appeal, this court has, quote, the duty to make an independent evaluation of the circumstances, unquote, Shepard v. Maxwell. During the jury selection process in Appellant Adelson's case, the trial court interviewed 130 potential jurors one-on-one to assess their knowledge and opinions about the case. Of those interviewed, 96 had heard about the case, and of those who had heard about the case, 54 had formed an opinion about it. Of those who had formed an opinion about the case, 53 believed Appellant Adelson was guilty. In other words, only one single potential juror who held an opinion, page 22, about Appellant Adelson's guilt believed he was not guilty or could have been wrongfully charged. During the potential juror interviews, the jurors stated that the sources of their knowledge about the case included the Tallahassee Democrat, local news broadcasts, cable news specials like 2020 and Dateline, court TV broadcasts, CNN, podcasts, YouTube, radio, social media, documentaries, neighbors, friends, parents, co-workers, and some who stated that they had watched the co-conspirators' trials. Several jurors explained the notoriety of the case. I've been around long enough in this town to know it. Another colorfully put it, it's a tragedy. It's been over this community as long as it has. I mean, you'd have to live under a rock not to know about it. I don't really know more than the average citizen, just what you hear, but like I said, I know it's been ongoing for quite a while, and it's just a tragedy it's taken this long to find peace for the family. Yet another expressed that she consumed media about the case, quote, every chance I got, really, unquote, and that the impact it had on her is that it sticks in your mind. Juror after juror confirmed that the media they consumed had, page 23, taken the position that Appellant Adelson is guilty or was involved somehow in the murder. Most troubling, however, is the fact that all the jurors who had already formed an opinion about appellant Adelson's guilt or innocence, totaling over 50 jurors, all but one of them held the view that he is guilty. The court: based on the information that you know, have you formed an opinion concerning Mr. Adelson's guilt or innocence? Prospective juror: somewhat, probably, yeah, more of bias. The court: what is that opinion? Prospective juror: probably he's guilty. Mr. Dubin, the defense counsel: and what is that opinion? Prospective juror: I think he's guilty. The court: based on what you do know about this matter, have you formed any opinion as to the guilt or innocence of Mr. Adelson? Page 24. Prospective juror: well, I was kind of shocked to learn that the trial was still going on because, based on everything I read, I kind of thought he was guilty and it was already done, or at least assuming this is who I think it is, the brother of the wife. The court: but you believe that he is guilty in some manner? Prospective juror: well, I thought he had already been convicted. So, I guess my mind already thinks that. The court: are you able to set aside any knowledge that you've previously learned about this matter and disregard it and render a verdict solely on what will be presented in court as evidence? Prospective juror: may be difficult just because of, how much time this has come up over the last several years. I think I could. But honestly, we all have stuff in the back of our mind. The court: I understand. What you're telling me is just conversation speech, but it is somehow equivocal. I'm going to need a more specific answer. Are you capable of disregarding this information and rendering a verdict only on what you will hear as evidence in the courtroom? Prospective juror: no, that would be difficult. Mr. Dubin: well, I'm asking you. Page 25. Prospective juror: yeah, this has been going on for so long. Honestly, we all have opinions on it. Mr. Dubin: yeah. Prospective juror: and being a local, we do. So we kind of formulate opinions. But at the same time, I understand that this is very serious. So if there's actually evidence that shows this could not have happened, I'd be open to it. Mr. Dubin: you'd be open to that? Prospective juror: yeah. Mr. Dubin: but your current position is that you think he's guilty. Prospective juror: yeah. And I only know what's in the newspaper. I don't know if that's right or correct or not. The court: very well. Based on your knowledge of this matter, have you formed an opinion as to Mr. Adelson's guilt or innocence? Prospective juror: I think he has a fair amount of significant implication on this. Is he guilty? I cannot say. That would be my leaning. I can say that. Mr. Dubin: I'm asking you, is it fair to say, page 26, that your starting point is that he's probably guilty? Prospective juror: that would be my starting point, yes. The court: all right. Based on what you know at this time, do you have an opinion about Mr. Adelson's guilt or innocence? Prospective juror: yes. Court: what is your opinion? Prospective juror: I think he's guilty. Mr. Dubin: and your words were, I think he's guilty, and that's fine. Just tell me why you came to that conclusion. Prospective juror: based on what I've heard in the news so far? The court: based on everything that you know, do you have an opinion about Mr. Adelson's guilt or innocence? Prospective juror: I do have an opinion. The court: what is your opinion? Prospective juror: guilty. Page 27. The court: are you able to disregard this opinion? Prospective juror: I am not. The court: based on what you know, do you have an opinion about Mr. Adelson's guilt or innocence? Prospective juror: just what I saw on TV. The court: okay. That does not exactly answer the question. Do you have an opinion from what you saw on television concerning Mr. Adelson or his guilt or innocence? Prospective juror: everything points to guilty. The court: have you formed an opinion based on what you've learned or what you know concerning Mr. Adelson's guilt or innocence? Prospective juror: I would have to say yes. The court: what is that opinion? Prospective juror: probably guilty. The court: based off what you know about the matter from either the podcast or the news reporting, do you have an opinion about Mr. Adelson's guilt or innocence? Page 28. Prospective juror: I think I do, yeah. The court: what is that opinion? Prospective juror: I think he's guilty. The court: are you capable of disregarding this opinion? Prospective juror: no. The court: or is it firmly entrenched? Prospective juror: no, I don't think I could disregard it. I don't think it would be right for me to serve on this jury. The court: based on what you know, Do you have an opinion about Mr. Adelson's guilt or innocence? Prospective juror. I do. The court. What is your opinion? Prospective juror. Guilty. Prospective juror. Yes, I have an opinion. The court. Please share them. Page 29. Prospective juror. Oh my goodness. The court. Turn your back around again. Prospective juror. As far as guilty or innocence? The court. Yes. Do you have opinions on that subject matter specifically? Prospective juror. Yes, sir. I would say he's guilty. The court. Based on those discussions or what you know, have you formed an opinion? Prospective juror. I have. What is that opinion? Prospective juror. Guilty. The court. And is this a firm opinion or one that you believe you can disregard? Prospective juror. I'm about 90%. The court. Based on what you've learned or what you already know, do you have an opinion as to the defendant's guilt or innocence? Prospective juror. Unfortunately, yes. The court. What is that opinion? Page 30. Prospective juror. Guilty. The court. All right. Based on what podcast and what you have learned, based on that podcast and what you have learned from it, did you form an opinion about Mr. Adelson's guilt or innocence? Prospective juror. I did. The court. What is your opinion? Prospective juror. From the podcast, guilty. The court. Okay, based on what you've learned about either the news reports or other sources, have you formed an opinion on Mr. Adelson's guilt or innocence? Prospective juror. Pretty much so. The court. What is your opinion? Prospective juror. That he's guilty. The court. Okay, so other than what you've learned through the local news, do you have an opinion at this point as to Mr. Adelson's guilt or innocence? Prospective juror. Being honest? The court. That's what we need from you. Prospective juror. Everything that I hear, he's guilty, my opinion. The court. Based on what you've learned, either through internet articles or other means, page 31, do you have an opinion as to Mr. Adelson's guilt or innocence? Prospective juror. I have formed my own opinion by what I've read. The court. What is that opinion? Prospective juror. From what I've read, I think that he's guilty. The court. You've done nothing wrong. You are under no instructions from the court or anyone else. Based on everything that you know, do you have an opinion concerning Mr. Adelson's guilt or innocence in this matter? Prospective juror. Yeah. The court. What is your opinion? Prospective juror. He's guilty. The court. Okay. And from what you Googled and what you learned, do you have any opinions, page 32, concerning Mr. Adelson's guilt or innocence? Prospective juror. I do. The court. Please share that opinion with us. Prospective juror. I'm leaning more towards guilty, because just reading the details for like how everything worked out and who's already been convicted. The court. Based on what you know, do you have an opinion as to Mr. Adelson's guilt or innocence? Prospective juror. I would think he's guilty. The court. So you believe he's guilty? Prospective juror. Yeah. The court. Based on what you learned from the podcast, do you have an opinion about Mr. Adelson's guilt or innocence? Prospective juror. I think he's guilty. The court. Okay. Based on what you know, do you have an opinion about Mr. Adelson's guilt or innocence? Page 33. Prospective juror. I think he's guilty. The court. Is this a firm belief, or is that something that you're capable of setting aside and disregarding? Prospective juror. I don't know. I know when I was reading about it, I felt pretty sure he was guilty. Prospective juror. I'm very well informed about the case. The court. All right. Is this through your professional capacity as mayor or just through other means? Prospective juror. No, just media. Talk about town. The court. Okay. Do you regularly watch the news or read the Democrat? Prospective juror. Are they here? Yes. The court. Okay. Have you recently consumed any information about this case? Prospective juror. I have. The court. Based on what you know, do you have an opinion as to Mr. Adelson's guilt or innocence? Prospective juror. Yes. The court. What is that opinion? Page 34. Prospective juror. Guilty. The court. And is this a firm opinion, or are you capable of setting it aside and disregarding it? Prospective juror. Pretty firm. In light of the dozens of prospective jurors who admitted to being exposed to publicity about the case, and as a result, having formulated the opinion that Appellant Adelson is guilty, defense counsel moved for a change of venue. Mr. Dubin. Your Honor, just for the record, I'm going to make a motion for a change of venue at this time. I think that voir dire has demonstrated that it's impossible for Mr. Adelson to get a fair trial in the city of Tallahassee. I know that some folks have passed through certainly not anything less than a very rigorous process, which the defense certainly appreciates, but I think as demonstrated by the answers from the mayor of the city right down to the citizens of the county, that there is not a single person except for one man whose opinion I discount that has walked back here and said anything other than this man is guilty, that he's guilty, that he's guilty. I think that there have been a number of people that have been exposed to media attention that are still in the pool that have expressed that they have been exposed to media about the case and then represented to the court that they have an opinion. I frankly find that, not that they're intentionally trying to deceive the court, I just find it near impossible given the weight and saturation of the media attention in this case. Page 35. So we would respectfully ask that this court move these proceedings to a town that there has not been as much coverage of the case. The court, where would you suggested venue be? Mr. Dubin. My suggested venue would be somewhere in South Florida, somewhere in the middle of the state, somewhere where the Tallahassee Democrat doesn't have the circulation that it has, and WCTV is not the local TV station. I'll leave that in the court's discretion. The court, state? Ms. Kappelman, the prosecutor. I disagree, Your Honor. In less than 2 days, we've got 60 jurors that have passed the test on publicity, and we're ready to go to the next phase. The court. I will find in examining the prospective jurors individually that some of them have indicated they have no exposure to this case whatsoever. I cannot give a specific number count. However, I believe the record will bear this out. And additionally, the other jurors who have had either exposure to the local media or have indicated some form of an opinion, they have indicated that they will follow the law and that will render a verdict that's based solely on the evidence. On those grounds, I will not find that the pretrial publicity is such that the change of venue motion must be granted, and I'm going to deny it at this time. Page 36. The trial court should have granted the motion for change of venue, as explained by the Florida Supreme Court in Manning, quoting, "Our state and federal constitutions guarantee to criminal defendants a right to a fair trial by an impartial jury. As this court had noted in Singer v. State, every reasonable precaution should be taken to preserve to a defendant trial by such a jury, and to this end, if there is a reasonable basis shown for a change of venue, a motion therefore properly made should be granted. A change of venue may sometimes inconvenience the state, yet we can see no way in which it can cause any real damage to it. On the other hand, granting a change of venue in a questionable case is certain to eliminate a possible error and to eliminate a costly retrial if it be determined that the venue should have been changed. More important is the fact that real impairment of the right of a defendant to trial by a fair and impartial jury can result from the failure to grant change of venue." Unquote. Manning. The motion for change of venue in this case, quote, "was amply supported by evidence which established that the community was so pervasively exposed to the circumstances of this incident that the defendant could not secure a fair and impartial trial," unquote, in Tallahassee, Florida. Manning. The record further reflects, and at least one juror admitted, that, quote, "hostility existed in the community against the accused to the extent that it would be difficult for any individual to take an independent stand adverse to this strong community sentiment." Page 37. Based on the individual perspective jury voir dire, it was clear that the community was pervasively exposed to the circumstances of the case and that prejudice, bias, and a preconceived opinion was the natural result. See Manning. In accordance with McCaskill, the motion should have been granted because the minds of the citizens of the Tallahassee community were infected by knowledge of the crimes, such that they could not possibly put it out of their minds. The jury selection process established the extensive and highly prejudicial nature of pretrial publicity and the difficulty in actually selecting a jury. This court has, quote, "the duty to make an independent evaluation of the circumstances," unquote, Shepard. In doing so, Appellant Adelson urges the court to review the jury selection transcript in its entirety to fully understand the pervasiveness of the pretrial publicity and its effect on the potential jurors and the community at large. Additional areas in the record for this court's independent evaluation of the circumstances are as follows, page 38. During jury selection, the trial court specifically asked potential jurors to name the sources from which the potential jurors had received their information, and their answers reflected an expansive array of sources. This question was asked on the basis of Appellant Adelson's motion to use a juror questionnaire, which also cited the extensive and extraordinary media coverage of this case as the basis for its need. Quote, over the last 9 years, this case has quite literally generated thousands of print and online news articles, network and cable specials, podcast, roundtable discussions, and YouTube videos, each spawning hundreds, if not more, of online comments from the public, unquote. Further record evidence of the intense and enduring media coverage of this case is available for this court's review in Appellant Adelson's defendant Charles Adelson's unopposed motion for protective order. Response in opposition. At that hearing, the parties agreed that the media coverage was extraordinary, and the state went on record to argue that ensuring Appellant Adelson's right to a fair trial was of the utmost importance, and accordingly, the protective order was necessary. Mr. Evans, the prosecutor. Your Honor, just like I said, we're not opposed to the motion. Our primary purpose is and focus is, as the courts, is in considering this, that we want to ensure the defendant has his constitutional right to a fair trial, and we would want to do everything we could to avoid any possible change of venue in this case. Page 39. It needs to be tried here in Leon County. In making its ruling on the motion for protective order, the trial court made the following findings. The court has reviewed the interviews, and as Mr. Rashbaum noted, this is a balancing test. For the sealing of the evidence, there must be an overriding interest that it is likely to be prejudiced if the items are released to the public. There needs to be a serious and imminent threat to the administration of justice, as Mr. Tobin has noted. In this case, that interest is the defendant's right to a fair trial by an impartial jury. The court recognizes the public's right to the public record, but in this case, the defendant's need for a fair and impartial jury overrides that public interest. It is the responsibility of the judicial branch to ensure that all parties receive a fair trial. As Mr. Tobin noted, there is a 3-part test in the Miami Herald versus Lewis case that the court must adhere to, and that 3-part test is met for the sealing of these proffers. Number 1, there has been a wealth of pretrial publicity. It is a well-known case, particularly in this community, page 40. Number 2, the public disclosure of that discovery material would further aggravate the pretrial publicity. It would draw attention to this case, particularly in this community. And number 3, the only measure available to the court until a jury is selected is to cut off the potentially prejudicial publicity at its source before it is disclosed to the public. The disclosure of these discovery materials would be big news in this small community, potentially infecting the entire jury pool, even those who at this point may be acceptable jurors. Those without an opinion at this time may form an opinion, thereby reducing the jury pool drastically. This sealing is limited as much as practicable until Ms. Magbanua testifies at trial or until the conclusion of the trial. So, in short, the sealing is necessary to prevent a threat to the administration of justice. There is no other alternative that is available, and the sealing is no broader than necessary to accomplish this purpose. Therefore, the motion is granted. To be sure, a trial court was so concerned about the media, page 41, the media attention in the small community of Tallahassee that it granted Appellant Adelson's request for a protective order, citing that the case is well known and the media coverage so pervasive, particularly in this community, that it threatened the fair administration of justice. In doing so, the court confirmed Appellant Adelson's fear that he could not receive a fair trial in the small community of Tallahassee. In Patton v. Yount, the United States Supreme Court granted certiorari to consider the problem of pervasive media publicity that now arises so frequently in the trial of sensational criminal cases. The United States Supreme Court held that the relevant question is not whether the community remembered the case, but whether the jurors at Yount's trial had such fixed opinions that they could not judge impartially the guilt of the defendant. Most relevantly here is the fact that 54 potential jurors had, prior to jury selection, already formulated an opinion about the guilt or innocence of Appellant Adelson, and 53 of them believed that Appellant Adelson is guilty, page 42. This statistic speaks volumes to both the extent of publicity and its prejudicial effect. The question from Patton in evaluating juror prejudice, whether the jurors had such fixed opinions that they would not judge impartially the guilt of the defendant, must be answered in the affirmative. Additionally, in some instances, quoting, the percentage of prospective jurors professing an extrinsic knowledge of the case or a fixed opinion has been used to determine whether pervasive community prejudice exists, unquote, Rawling. In Murphy, a case from Florida, the United States Supreme Court evaluated these percentages as follows. In the present case, by contrast, 20 of 78 persons questioned were excused because they indicated an opinion as to petitioner's guilt. This may indeed be 20 more than would occur in the trial of a totally obscure person, but it by no means suggests a community with sentiments so poisoned against a petitioner as to impeach the indifference of jurors who displayed no animus of their own. Murphy. The Florida Supreme Court in Rawling explained that, consistent with the Murphy rationale, Florida courts have found in other cases where similar percentages of prospective jurors, page 43, voiced a bias during voir dire, that a change of venue was not required because the partiality of certain individual venire members did not reflect a pervasive prejudice infecting the entire community. Rawling. Here, though, of the more than 4 potential jurors who had formed an opinion about Appellant Adelson's guilt based on their exposure to the media or merely just having been around long enough in town to know it, all but one had a preconceived opinion that Appellant Adelson is guilty. Mr. Dubin. Yeah, I understand, Your Honor. It's just that you saying that he's innocent is oftentimes disconnected with how they feel. And how they feel is that there hasn't been not a single prospective juror, not one in a marathon session yesterday. That said, I read about the case, and you know what? I think they may have wrongfully accused him. The media, the court, there actually was one, Mr. Rashbaum. There is the one, Mr. Dubin. If you're going to rely on that, I'll repeat what I said. There wasn't one rational person who came in here yesterday and said, boy, I read the media and I think they got the wrong guy. The media has been an avalanche of accusations and inference about this man's guilt, page 44. I think I've made my record further. Adverse pretrial publicity can create such a presumption of prejudice in a community that the jurors' claims that they can be impartial should not be believed. Patton. It is entirely realistic on this record to imagine that a juror's assertion, either that they have no information about the case or have not formed an opinion, is not to be believed because there were at least 2 instances where a juror lied to the court about his preconceived opinion as to the guilt of Appellant Adelson. The court. Based on what you already know, have you formed any opinions as to the guilt or innocence of Mr. Adelson? Prospective juror. I don't know anything about him. The court. Can you set aside whatever knowledge that you have obtained in the past, disregard it, and render a verdict solely on what will be presented as evidence in this case? Prospective juror. Sure. Yes. Sure. The court. Do you believe that you're capable of being fair and impartial as a juror? Page 45. Prospective juror. Yes. The court. Is there anything that will prevent you, hardship-wise, from serving as a juror for possibly 3 weeks? Prospective juror. No. Mr. Dubin, continuing the questioning of the same prospective juror. Sir, have you ever posted anything to social media about this case? Prospective juror. No. Mr. Dubin, are you sure about that? Prospective juror. Pardon? Mr. Dubin, are you sure about that? Prospective juror. Yeah, I mean, this was how many years? What, 2014? I think is what someone said in there today. The court. That was part of the statement of the case. Prospective juror. Yeah, part of the statement. Okay, 2014. So yeah, I don't think I have. Mr. Dubin. Might you have and just don't remember it? Or, page 46, prospective juror. Gosh, there's a lot of things I may not remember from 2014. I mean, Mr. Dubin, let me ask you this, Mr. Redacted Name. Let me ask you this, Mr. Dubin. Do you recall posting something where you talked specifically about Mr. Adelson and ending his life? Prospective juror. Ending his life? Mr. Dubin. Yes. Prospective juror. No. Mr. Dubin. Can I have the prospective juror step out for a moment and speak to the court? The court. That's fine. Bailiff, you can escort the juror out. We'll call you back in a moment. Mr. Dubin. And I don't know if it was for the same reason, Your Honor, but this juror has posted to social media about the case. I'm going to read the post into the record and then print it at the break for Your Honor. And we have confirmed that it is him. We have a photo of him from his public social media account. He posted about the case in 2019. Quote, I am sad for his parents. If it were my son, I would want to participate in terminating his life. Let's end this deep mental distress once and for all. He wrote that about Sigfredo Garcia, page 47. And then, when the prosecution was announced in this case, he posted, surprise, surprise, about Mr. Adelson. All over his social media, he's posting about the case. It's his picture. Looks exactly like him. It's from his public Facebook account, I believe. I can print the court exhibit. It's not my intent to further embarrass a prospective juror. To be clear, there was a prospective juror who represented that he did not have an opinion about appellant Adelson's guilt and could be fair and impartial, and yet that juror had actually posted on social media about appellant Adelson, including the idea that if he were the parent of Dan Markel, he would want to kill co-conspirator Sigfredo Garcia. The prospective juror also denied even making the post. In another instance, a prospective juror claimed not to have an opinion about the appellant Adelson's guilt, but another juror reported that he had said he's guilty in the jury assembly room within earshot of other jurors. Accordingly, if, quote, adverse pretrial publicity can create such a presumption of prejudice in a community that the jurors' claims that they can be impartial should not be believed, unquote, and there were two instances where, page 48, the trial court actually discovered that prospective jurors' claims of impartiality should not be believed, then it follows that the presumption of prejudice against appellant Adelson in Tallahassee, Florida, should attach. Here, of the 12 jurors who actually sat in judgment of appellant Adelson, 8 had media exposure to the case in some manner. Considering the undisputed, extreme nature of the news and media coverage in this case and the smaller population in Tallahassee, Florida, the motion for change of venue in this case was amply supported by evidence which established that the community was so pervasively exposed to the circumstances of this incident that appellant Adelson could not secure a fair and impartial trial in Tallahassee, Florida. In Manning, the Supreme Court of Florida wrote in summation, although the evidence against the defendant in the present case is quite strong, it is possible that another jury, uninfluenced by the passion existing in Columbia County at the time of this trial, might have reached a different verdict. Page 49. The same can be said of appellant Adelson's case. It is possible that another jury, uninfluenced by the passion existing in Tallahassee at the time of appellant's trial, might have reached a different verdict. As such, the motion for change of venue should have been granted to guarantee that appellant Adelson received a fair trial by an impartial jury to which he is constitutionally entitled. The trial court was aware of the problem of the pretrial publicity, even taking the precaution of granting a protective order so that the media could not access or publish additional evidence that would have been prejudicial to appellant Adelson leading up to the trial. But the case law makes clear that, quote, every reasonable precaution should be taken to preserve a defendant's trial by such a jury, and to this end, if there is reasonable basis shown for a change of venue, a motion therefore properly made should be granted, unquote, Singer. The defense made the showing of, and the record confirms, a reasonable basis for the change of venue. While it may have inconvenienced the state to move Appellant Adelson's trial to another venue, page 50, this court should, in its independent evaluation of the circumstances, Shepard, follow the Florida Supreme Court's analysis in Singer that judiciously weighs the importance of the defendant's fair trial against any inconvenience caused. Quoting, "More important is the fact that real impairment of the right of a defendant to trial by a fair and impartial jury can result from the failure to grant change of venue," unquote. The Singer court also appropriately pointed out that it can, quote, "see no way in which it can cause any real damage," unquote, to the state for the court to grant the motion for change of venue. A change of venue, the Florida Supreme Court said in Singer, even in a questionable case, would be, quote, "certain to eliminate a possible error and to eliminate a costly retrial if it be determined that the venue should have been changed," unquote. Appellant Anderson asserts that his case was not a questionable case and plainly warranted the change of venue to protect his constitutional rights to a trial by an impartial jury under Article 1, Section 16 of the Florida Constitution and the Sixth Amendment to the United States Constitution, page 51. Even if it could be argued that a change of venue was not warranted when jury selection began, as jury selection unfolded, it became apparent that the prejudice against Appellant Adelson in Tallahassee threatened Appellant Adelson's constitutional right to a fair trial by an impartial jury. Counsel appropriately moved for a change of venue in light of these insurmountable obstacles to fairness, i.e., the pervasive exposure to pretrial publicity that painted Appellant Anderson in such a bad light that 53 out of 54 jurors who had formed an opinion about the case believed Appellant Adelson to be guilty, as well as evidence of at least 2 jurors who affirmatively lied to the court about their negative opinions of Appellant Anderson. Simply put, if this case does not meet that standard for a change of venue, it is hard to imagine a case that would.
Terrific job to Ed. We are so incredibly grateful to have an amazing speaker whose credits often get mistaken for AI. But I can assure you, we do not use AI on this channel. We are 100% human. I will see the rest of you shortly for part 3, so stay tuned. Again, my name is Maya with Deep Dive True Crime and Mentor Lawyer Justice Network. Hi everyone, my name is Maya with Deep Dive True Crime and Mentor Lawyer Justice Network, and I am back with part 3 of Charles Adelson's initial brief. In this video, Ed will continue reading on page 52, and this part will include the entirety of arguments 2 and 3. Now, I'll pass it on to human Ed, so let's get started.
Page 52. 2. The trial court abused its discretion when it denied Appellant Adelson's motion to strike the venire panel after several potential jurors reported to the court and the parties that other potential jurors were having conversations together about the case after being instructed not to do so. A. Standard of review. A trial court's ruling denying a motion to strike the jury panel is reviewed on appeal pursuant to the abuse of discretion standard of review. See Morris v. State. B. Argument. During the initial voir dire process, prospective jurors reported several instances of other prospective jurors discussing the case, which was against the instruction of the trial court. Prospective juror. The only thing this person said is that they thought it was the FSU case. It had something to do with the murder of the professor. And I mean, that was really it. She didn't go into detail. I said, I think they had kids. I think it was a divorce. Mr. Dubin, defense counsel. Right. Did anybody else mention anything about the case that you heard of? Prospective juror. No. The guy behind me cursed a little bit because he said, well, we're screwed because we're going to be here all day. But I mean, Mr. Dubin, what curse word did he use? Page 53. Prospective juror. Well, he used the F word, if I'm being honest. Mr. Dubin. Did anybody express any opinions about Mr. Prospective juror? The guy behind me did. Mr. Dubin. Okay. Prospective juror. He said he's guilty. Mr. Dubin. So the young man said it. You were all crowded in the jury assembly room. So fair to say it was within earshot of others? Prospective juror. Oh, yeah. As a result, defense counsel moved to strike the panel. Mr. Dubin. Okay, given what you've learned from the juror name, I could tell you, Your Honor, that it's extremely disconcerting to hearing that a prospective juror that just came in apparently has a strong opinion. That's one thing, that he came in and was apparently not honest with the court. What's more concerning is that he blurted it out loud in the assembly room. And in an abundance of caution and to protect my client's constitutional right, I'm going to move to strike the entire panel. We have no idea, without conducting an investigation, of who this young man and said this within earshot, page 54. You know, she didn't follow him around. He apparently wasn't sitting behind her the whole time, but this is not the first person we've heard say that they were reading about or discussing the case in the assembly room. And unfortunately, without getting to the bottom of it, I think in an abundance of caution, we need to strike the panel. Notably, the very next potential juror to be questioned confirmed that she and others had been discussing the case all day, I think, quoting, "We were just talking about it," despite the trial court having, quote, instructed everyone, "Do not discuss the case in any way that was fairly direct and specific for a reason," unquote. Importantly, that juror held a preconceived notion of appellant Adelson's guilt. Thus, defense counsel renewed the motion to strike the panel. Mr. Dubin. I'm going to renew my motion, Your Honor, to strike the entire panel. I think it's abundantly clear at this point that they're out there. This is now the third person, or at least the second, who has said they're all out there discussing the case. The court. Well, she is an imprecise speaker, but I am going to get this cleared up right now. Go ahead, Mr. Dubin. Yeah, just to complete the record, and I don't mean to belabor the point, Your Honor, page 55, the court. State, Mr. Dubin. Just real quick, the court. Go ahead, Mr. Dubin. Last thing I'll say is that she was not credible in my estimation at all when she denied what it was about. She went from saying, "We've been talking about it all day," and then she said, "Oh, just 9 years ago." I don't think she was being candid with the court. The court. State, Ms. Kappelman, the prosecutor. All I heard is that the jurors discussed the fact that this was the case they were here for jury selection on, and that it occurred 9 years ago. That doesn't indicate we should strike the panel. The court. I'm going to deny the motion to strike the panel. However, I'm going to go out there and reiterate to them not to discuss any matters pertaining to this case. If you all wish to come, it's up to you. The following proceedings took place in open court in the presence of the venire. The court. Juror name, you are excused. Have a good day. Everyone that is here remaining, I understand that there was some conversation in the jury assembly areas as to whether or not you would be brought for jury selection as to this case, page 56, when everyone previously heard me say there is to be no discussion concerning the subject matter of this case. Is anyone confused in any way as to what I'm saying? Raise your hand now because I want to get this cleared up. There was no audible response. The court. Until you are excused from jury selection, do not discuss in any manner the subject matter of this case. Is anyone confused? Is anyone not clear? Raise your hand because I want to get this cleared up. You can talk about anything else, but not about this case. We will resume with the individual voir dire. Juror name. Please come back. The following proceedings had outside the presence of the venire in the jury deliberation room. The court. Juror name. Were you discussing with Ms. Juror name or anyone else the subject matter of this case since you've come to this courtroom? Prospective juror. I did not mean to if I was. I think I mentioned I listened to a podcast. The court. Since coming to this courtroom, you talked about that with her? Prospective juror. I don't know if it was the court or was it downstairs earlier? Prospective juror. I think it was downstairs. The court. Okay. Did you have any conversations with anyone else since you've been up here in this courtroom about this case or the subject matter? Page 57. Prospective juror. No. And I thought I heard some people talking about it, and I just thought, like, that shouldn't happen. The court. In 3G, up here? Prospective juror. Correct. The defense proceeded to strike the juror for cause, and the trial court said, the court, all right, based on the totality of her responses, including the fact that there has been conversation in violation of the prior directive from the court about the case itself while they've been waiting to be interviewed, I am going to remove her for cause. From here, it's probably going to become prudent to ask each juror if they engaged in any conversations while waiting. Very soon thereafter, another potential juror disclosed that she had overheard conversations from potential jurors about the case. Prospective juror. I did hear, I think I heard one person's opinion that actually voiced like what they thought the case was, but Mr. Dubin, what was that opinion? Prospective juror. Like, I think the phrase was, I think he did it, page 58. Mr. Dubin, okay. Thank you very much for your candor. And do you recall, was that person sitting behind you, in front of you, beside you? Prospective juror. That was in a previous room other than this one. Mr. Dubin. Do you recall what the person looked like? The court. Male or female? Prospective juror. Female, maybe 50s or 60, if it's who I remember correctly. Defense counsel again moved to strike the jury panel. Mr. Rashbaum, defense counsel. So this is what we're now hearing about, a second person offering an opinion. We heard it was a male, a young kid. Now we're hearing it's female in their 50s and 60s. One of the primary constitutional rights is that a jury not discuss the case before the case is over. You're going to tell them that every single time that we take a break in this trial? And what we see is that within jurors 51 and 102, that constitutional right has already been violated. They're all tainted from 51 to 102. We have no idea what they've said out there, but we know from at least 5 jurors now, some of which have come in here and said that they believe he's guilty. They know that they are talking to other jurors out there. Judge, we have to get rid of jurors 51 and 102. They're tainted. We're creating a problem before we've even begun, page 59. The trial court denied the motion, but indicated that it would revisit it if the defense does an independent investigation that yields additional information. Defense counsel reiterated that, quote, the reality is, again, for the record, the reality is we have picked out of these 51 through what we've done right now, we've picked 13 potential jurors out of 51 and 102. And there's an issue with those jurors, and we all know it, unquote. Defense counsel continued that, quoting, I think it's prudent, Judge, in a capital case where a man's life is on the line, that if jurors, we know that jurors talked about it in the courtroom, and with all due respect, you scared the heck out of them when you went out there, so they're coming in here now and they're shaking, and they're not telling us everything, unquote. The trial court again denied the motion, and once again, the very next juror indicated that he heard someone, a different someone, discussing the case among the prospective jurors. Defense counsel renewed the motion yet again, and the trial court denied it. Page 60. In light of the trial court's repeated warnings to the potential jurors, there can be no doubt that the jurors were aware that they should not discuss the case prior to deliberations. The fact that discussions did, in fact, take place early clearly indicates an impropriety. See Scott v. State. Once a prima facie case of potential prejudice has been established, the burden is on the state to rebut the presumption of prejudice. See Amazon v. State. In the instant case, the trial court should have granted the motion to strike the jury venire panel in light of the multiple accounts of potential jurors talking about the case and in light of the fact that some of the jurors who had been discussing the case were the same ones who held a preconceived belief that appellant Adelson is guilty. Moreover, some of the comments reported were expressions of appellant Adelson's guilt. Therefore, the trial court's refusal to strike the jury venire was unreasonable based on the record in this case, page 61. When faced with the problem of the jurors violating the trial court's instructions not to discuss the case, the trial court removed for cause those particular jurors who admitted to talking about the case, and the trial court went back into the courtroom to instruct the jurors anew, or as defense counsel artfully phrased it, scare the heck out of them, not to have any discussion about the case, evidencing the trial court's belief in the allegations of improper juror discussions. But while removing some of the jurors who participated in the prohibited discussions was proper, it did not cure the problem. It is unknown how many jurors were exposed to the extrinsic and prohibited conversations, particularly since that question was not asked of every potential juror. It is also unknown whether any prohibited conversation was reported, as several potential jurors reported distinct comments or attributes of the declarants that other potential jurors did not. Defense counsel made this argument, and the trial court acknowledged this concern, remarking that, quote, "From here, it's probably going to become prudent to ask each juror if they engaged in any conversations while waiting," unquote, page 62. Nonetheless, the trial court did not strike the panel. Accordingly, the trial court abused its discretion because it was unreasonable not to strike the panel under the specific circumstances of this case. Protection of Appellant Adelson's constitutional right to a fair and impartial jury required the granting of the defense's motion to strike jurors 51 through 102, especially in light of the fact that only 13 of them had not already been excused. The trial court's action of keeping the panel in the face of mounting evidence that the jury panel had been tainted was error, and as a result, Appellant Adelson was denied his constitutional right to a fair trial. See U.S. Constitution Amendments 5:14. Page 63. 3. The trial court erred by precluding the defense from entering text messages that would have shown that Appellant Adelson and other alleged co-conspirators were communicating normally during the time leading up to Dan Markel's murder to rebut the state's contention that Appellant Adelson and the alleged co-conspirators were making phone calls about the murder during the time in question. A. Standard of review. Quote, "Relevant evidence is that which tends to prove or disprove a material fact," Grau v. Branham. Quote, "All relevant evidence is admissible unless its probative value is substantially outweighed by the danger of unfair prejudice or unless otherwise excluded by law," unquote. Quoting, "As a general rule, a trial court's ruling of the admissibility of evidence will not be reversed absent an abuse of discretion," McCrae v. State. Quote, "However, a trial court's discretion over such decisions is limited by the defense code and the applicable case law, and its interpretation of those authorities is subject to de novo review," unquote, Hendricks v. State. See also Twilligar v. State. Quote, "As a general rule," page 64, "a trial court's ruling concerning the admissibility of evidence will be sustained on review absent an abuse of discretion. Yet a court's discretion is not boundless, and it may be constrained by legal precepts such as the rules of evidence and the principle of stare decisis," unquote. Johnson v. State. Quote, "This court reviews evidentiary rulings for abuse of discretion. A judge's discretion is limited by the rules of evidence and by the principles of stare decisis. A trial court ruling constitutes an abuse of discretion if it is based on, quote, an erroneous view of the law or on a clearly erroneous assessment of the evidence," unquote. B. Argument. The trial court erred when it precluded the defense from entering text messages into evidence that would have shown that Appellant Adelson and alleged co-conspirators, Katie Magbanua, Donna Adelson, and Wendy Adelson, were communicating normally during and around the time of the murder. The trial court's stated reasons for excluding the communications were hearsay, relevance, and confusion of the issues, page 65. During its case, the state was permitted to introduce call logs and cell site tower information, which showed that Appellant Adelson and Ms. Magbanua were communicating directly before the murder, around the time of the murder, and after the murder took place, allowing the state to argue that the jury should infer that the communications pertained to the murder. In response, during the defense's case in chief, the defense sought to introduce text messages to rebut that inference. The proffered text messages showed that communications taking place during this time period were about wholly unrelated matters. The defense further argued that the text messages, as a collection or composite, showed that Appellant Adelson's state of mind was not someone conspiring to commit a murder. Nevertheless, the trial court excluded the text messages. Therefore, defense counsel argued, Mr. Rashbaum, defense counsel, in the state's case in chief, they were allowed to put in phone calls showing the arrows indicating that they have no idea of anything said on those calls, page 66. They're essentially the same thing as putting in text messages like this, except you actually see the content, right? The court, The chain of the traffic versus what is actually said? Mr. Rashbaum. They put in every call. Okay, they put in every call between these participants on those particular dates, which, by the way, correspond mostly to the days that I'm offering these text messages for. They put them in there for their own purposes. I think I should be allowed, under a 403 analysis, what's good for the goose is good for the gander, to put in the text messages to show the pattern or lack of a pattern of anything. And that's what these text messages show. But I can just ask the question, but I would like the record to reflect that under a 403 analysis, it was allowed for them. It's not being allowed for us. The court. I wouldn't exactly say it boils down to being that simple, but your objection is noted. Specifically as to what the state was permitted to demonstrate in their case in chief goes to either demonstrating motive or direct evidence of what they believe show the elements of the charges. As to these composite exhibits, and again, I don't want to get very deep into what the subject matter is, there are messages that either go to embarrassing of the other witnesses or litigants in this matter, matters that are wholly irrelevant, or matters that do not demonstrate in any way the theory of defense as the court understands it. If there are portions, again, that are specifically relevant to negating either the motive or any of the elements of the charges are not hearsay, as argued by the defense, page 67, I will consider those separately. But as a composite on the whole, the 403 issues, the relevance and hearsay issues, I believe compel me to deny their admission. Ultimately, defense counsel was permitted to ask appellant Adelson about the text messages. Question by Mr. Rashbaum. You've had the opportunity to review your text messages from June 2nd to June 7th, 2014? Answer by Charles Adelson. Yes, I have. Anything in those text messages out of the ordinary? No. They're text messages about what types of subjects? Work, personal life. Anything about a first attempted murder in Tallahassee? No, not at all. Anything about any sort of violence? No, not at all. Anything about any sort of panic? No, not at all. Page 68. The Sixth Amendment to the United States Constitution, as interpreted by the United States Supreme Court, guarantees a criminal defendant the right to present a defense. See Chambers v. Mississippi. See also Florida Constitution. Quote, at a minimum, criminal defendants have the right to put before a jury evidence that might influence the determination of guilt, unquote. Taylor v. Illinois. A criminal defendant's right to present a defense is essential to a fair trial. See United States v. Valenzuela Bernal. Quote, Florida law is clear that where evidence tends in any way, even indirectly, to establish a reasonable doubt of a defendant's guilt, it is error to deny its admission. Mateo v. State. Quote, thus, as a general proposition, any evidence that tends to support the defendant's theory of defense is admissible, and it is error to exclude it. Page 69. In this case, the excluded text messages tend to establish a reasonable doubt as to appellant Adelson's guilt. The state was permitted to show the jury that phone calls occurred between the alleged co-conspirators and to argue that the fact that the alleged co-conspirators were communicating on certain dates showed that they were conspiring about or at least discussing the murder. The defense wanted to show the actual substance of the text messages to the jury to negate the state's assertion that these alleged co-conspirators were discussing the murder and that the substance of the messages was in fact not about the murder, but were about normal things. Thus, it was error to exclude the messages. The error in excluding the messages was not harmless, as the state cannot meet its burden of proving beyond a reasonable doubt that the error did not contribute to the verdict. See State v. DiGiulio. Quote, the harmless error test places the burden on the state as the beneficiary of the error to prove beyond a reasonable doubt that the error complained of did not contribute to the verdict, or, alternatively stated, that there is no reasonable possibility that the error contributed to the conviction, unquote. Page 70. In applying the harmless error test, this court should examine the entire record, including, quote, a close examination of the permissible evidence on which the jury could have legitimately relied, unquote. It cannot be said that the fact that the jury was permitted to see phone calls between the alleged co-conspirators and not permitted to see that the substance of their communications, text messages, actually pertained to unrelated matters, and also gave no indication that they were conspiring to commit and or were actually committing a murder, did not contribute to the conviction of Appellant Adelson. Preventing the jury from seeing that, in fact, Appellant Adelson communicated normally with Magbanua, Donna Adelson, and Wendy Adelson during the relevant time period, and that his state of mind was not planning, conspiring, or discussing the murder of Dan Markel was extremely prejudicial to the defense. The trial court erred by ruling that 1, the state was permitted to use the chain of traffic phone calls because their evidence, quote, goes to either demonstrating motive or direct evidence of elements of the charges, unquote, but 2, the defense was not permitted to introduce the actual substance of communications between the alleged co-conspirators, page 71, and to show Appellant Adelson's state of mind. As explained above, this evidence tended to show a reasonable doubt as to Appellant Adelson's guilt and therefore should have been admitted. Accordingly, for the reasons set forth above, the trial court erred by preventing the defense from introducing the text messages between Appellant Adelson and the alleged co-conspirators. The improper exclusion of the text messages resulted in a violation of Appellant Adelson's constitutional right to a fair trial. See U.S. Constitution Amendments 5 and 14, Florida Constitution. Appellant Adelson is therefore entitled to a new trial.
Thank you, Ed, for your amazing reading. Now, let's be mindful that just because someone is very talented doesn't make them AI. I will see the rest of you for part 4 of Charles Adelson's initial brief, and make sure to check out our related playlist that covers this entire case. Again, my name is Maya with Deep Dive True Crime and Mentor Lawyer Justice Network. Hi everyone, my name is Maya and welcome back to the 4th and final part of Charles Adelson's initial brief. Ed will continue reading from pages 72 to 81. Now, let me pass it on to Ed.
Page 72. 4. The trial court improperly excluded relevant, accepted hearsay evidence that was highly probative to the theory of defense, i.e., a recorded phone call where Appellant Adelson made the statement that he had been extorted in the past, and this is not how extortion works. A. Standard of review. The standard of review set forth in Claim 3 also applies to this claim. B. Argument. When a defendant seeks to introduce his own out-of-court statement for the truth of the matter asserted, it is inadmissible hearsay. See Cotton v. State. However, if a defendant's out-of-court statement is not offered by the defendant to prove the truth of its content, it is not hearsay and should be admitted, provided the purpose for which the statement is being offered is relevant to a material issue in the case. See id. Quoting, even though a particular statement might not be admissible to demonstrate its truth or falsity, this does not compel a conclusion that the same statement is not admissible to show the declarant's state of mind, unquote, Lark v. State. Page 73. Appellant Adelson testified during the defense's case in chief. During Appellant Adelson's testimony, he explained what he was doing during the time surrounding the bump. Relevantly, he said that he told his father, Dr. Harvey Adelson, that he believed that the alleged extortionists from April 2016, the bump, were actually the police. The next day, Appellant Adelson discussed the matter on a phone call with his mother, Donna Adelson, which the FBI recorded. The defense attempted to move the phone call into evidence as Defense Exhibit 100, but the state objected on hearsay grounds. The defense then proffered the recorded phone call. On the phone call, Appellant Adelson asked Donna Adelson whether Harvey Adelson told her what they spoke about. On the recorded call, Appellant Adelson told Donna Adelson that, quote, it's not done like that. It's not. I know for a fact it's not. It's not done like that at all, unquote. After hearing the proffer, the trial court asked defense counsel the following question. With regard to hearsay objection, the part that really stuck in my ear was your client saying it's not done in this way, page 74. What is his qualification to essentially make this opinion if this is not hearsay? Defense counsel responded that appellant Adelson had been extorted before by Dan Markel's killers, and he knows it is not done this way, i.e., the way that the FBI was doing it via the bump. The trial court responded, assuming there are many ways to skin a cat beyond the one way in which he's alleging to have been extorted, what is his foundation to make this opinion? Defense counsel explained that the opinion is based on appellant Adelson's past extortion experience, i.e., the theory of defense, and that the statement would have been an exception to the hearsay rule because it was being offered to establish appellant Adelson's state of mind at the time of the call. Despite this explanation, the trial court sustained the hearsay objection and did not allow the admission of the phone call into evidence. For the reasons set forth below, the trial court's ruling was erroneous. As an initial matter, the trial court's inquiry into appellant Adelson's, quote, basis of opinion, unquote, was not the appropriate consideration, and the fact that the trial court so inquired illustrates that the trial court misconstrued the question to be decided, page 75. The basis of the state's objection was hearsay. The Florida Evidence Code defines hearsay as, quote, a statement other than one made by the declarant while testifying at the trial or hearing offered in evidence to prove the truth of the matter asserted, unquote, Florida statutes. If the statement is offered for some purpose other than its truth, it is not hearsay. See Penalaver v. State. Quote, if the statement is offered for some purpose other than its truth, the statement is not hearsay and is generally admissible if relevant to a material issue in the case, unquote. The statement of appellant Adelson that, quote, this is not how extortion is done, unquote, was not being offered to prove the truth of the matter asserted, that is, that extortion is not done in the particular way that the FBI was doing it. Rather, the statement was to be used to show that appellant Adelson believed that the police were behind the bump extortion because he had been previously extorted by Dan Markel's killers. As such, having been a prior victim of extortion, which was the defense's theory, and this statement made in April 2016 would have corroborated the defense theory, was appellant Adelson's state of mind, page 76. The trial court's inquiry of defense counsel was erroneous because the trial court's inquiry focused on the truth of the matter asserted, i.e., that appellant Adelson needed to have a sufficient basis of knowledge regarding extortion in order for the statement to come into evidence. But the opposite is true. If appellant Adelson was offering the statement for the truth of the matter, that extortion is done in a particular way, established by some basis of knowledge of appellant Adelson's, then the statement would be hearsay. Instead, the statement was offered to demonstrate appellant Adelson's state of mind, which was that he believed the police were behind the bump because he had previously been extorted and it was not done in this way. Since appellant Adelson was offering the statement for his state of mind, it was an exception to the hearsay rule. See Everett v. State. Quoting, an out-of-court statement offered for the truth of the matter asserted is generally inadmissible hearsay. However, the same statement may be admissible to prove a variety of issues besides the truth of the matter, such as the declarant's state of mind, unquote. Page 77. Therefore, the trial court erred as a matter of law in concluding that the out-of-court statement of appellant Adelson regarding this is not how extortion is done was hearsay because the testimony was not offered in evidence to prove the truth of the matter asserted. Given that the statement was not hearsay, it should have been admitted, provided that the purpose for which the statement was being offered was relevant to a material issue in the case. See Cotton. Although the trial court did not reach this step because it found that the statement was hearsay, appellant Adelson asserts that the purpose for which the statement was offered was relevant to a material issue at trial. In this case, appellant Adelson's defense was that after the murder of Dan Markel, he was contacted by the killers through someone he knew, and he was told that he needed to pay money, he called this extortion, or else he would be killed. and that he did in fact pay the extortion money to avoid being killed, i.e. the first extortion. Exclusion of the phone call, in which Appellant Adelson said in 2016, 7 years before Appellant Adelson's case went to trial and 6 years before his arrest, that it's not done like that, in reference to the previous extortion by the killers of Dan Markel, page 78, was directly relevant to the material issue of whether he was extorted by the killers after they killed Dan Markel, and exclusion of the statement was extremely prejudicial, since it was a statement made in 2016 before anybody was arrested in this case. That would have corroborated the theory of defense. The error in this case was not harmless. The state cannot meet its burden in this case by proving beyond a reasonable doubt that the error did not contribute to the verdict. See State v. DiGiulio. Stated another way, the state cannot prove beyond a reasonable doubt that the result of the trial would not have been different if the jury heard Appellant Adelson's statement that he was extorted before the 2016 bump, many years before his arrest. In other words, the defense that Appellant Adelson was extorted by Dan Markel's killer would have been corroborated by the statement, which was made on a recorded line long before Appellant Adelson's arrest. Instead, the jury was left with Appellant Adelson's mere testimony that he was extorted by the killers without the affirming evidence from 6 years before his arrest. As such, the excluded statement was highly relevant and crucial to his defense, page 79. Accordingly, for the reasons set forth above, the trial court erred by excluding Appellant Adelson's statement from 2016 recorded phone call. The improper exclusion of the call resulted in a violation of Appellant Adelson's constitutional right to a fair trial. See U.S. Constitution Amendment 5 and 14 and Florida Constitution. Appellant Adelson is therefore entitled to a new trial. Page 80. 5. Cumulative error. A. Standard of review. Appellant Adelson submits that this claim presents a pure question of law that is subject to the de novo standard of review. See Williams v. State. Quote, "We have de novo review over a pure question of law," unquote. Argument. Appellant Adelson asserts that in light of the errors set forth above, he was denied his constitutional right to a fair trial. See U.S. Constitution and Florida Constitution. In support of his argument, Appellant Adelson relies on Broomfield v. State, wherein the 5th District Court of Appeals stated, Appellant Raymond Broomfield, Jr. challenges the judgment and sentence entered after he was found guilty by a jury of trafficking in cannabis and cultivation of cannabis. Broomfield contends that the state's improper questioning of investigating deputies and improper arguments during the closing argument constitute fundamental error. We agree and reverse and remand for a new trial. While the prosecutor's questions and comments, standing alone, may not rise to the level of fundamental error, page 81, the cumulative effect of the prosecutor's errors denied Broomfield a fair and impartial trial. See Slagle v. State. The cumulative effect of the prosecutor's errors denied Slagle a fair trial. Freeman v. State. Finding that the cumulative effect of prosecutors' errors, which included improper bolstering of police witnesses, impermissible burden shifting, and improper references to facts not in evidence, required a new trial. We decline to address the other issues raised by Broomfield, reversed and remanded for a new trial. As in Broomfield, in the instant case, the cumulative effect of the errors in this case denied Appellant Adelson a fair and impartial trial.
Very serious.
In the 1st District Court of Appeal, State of Florida, Charles Adelson Appellant versus State of Florida Appellee. Appellee's answer brief. Beginning on page 17. Summary of the argument. Because Adelson accepted his jury without reviewing his objection to venue, he cannot argue on appeal that his trial should have been removed from Leon County but a change of venue was unwarranted since most of the Leon County residents who assembled for Adelson's jury selection had not prejudged Adelson's case. 2. By accepting his jury and not renewing his motion to strike the entire jury pool, Adelson waived his second argument on appeal. But Adelson's motion to strike the entire jury pool was meritless because it was based on isolated comments that could not have influenced all the prospective jurors. 18. 3. Adelson failed to demonstrate the relevance of his exhibit containing more than 400 text messages. In any event, Adelson testified about the content of these messages. It was also better that the jury did not see the vulgar texts within Adelson's exhibit. 4. Adelson's out-of-court statement about knowing how extortion worked was hearsay because they were offered for the truth of the matter asserted, that Adelson had experienced extortion. Adelson is also wrong that his statement fell under the state of mind exception to the hearsay rule. The state of mind exception only applies to statements about the future acts of the declarant, not the past acts of other people. And 5, Adelson's 4 other arguments lack merit, and Adelson does not cite any additional errors in his initial brief. Adelson's cumulative error argument, therefore, fails. Page 19. Argument. 1. A change of venue was unwarranted, and Adelson's argument is procedurally barred. Adelson contends that the trial court should have granted his oral motion to change venue, but Adelson affirmatively accepted his jury, thereby waiving all the objections he made during jury selection. Also, the record shows that Leon County residents were perfectly capable of deciding Adelson's case based on the evidence presented in court. A. Adelson waived his change of venue argument by accepting the jury without objection. At the completion of jury selection, the trial court asked Adelson if he accepted the jury. Adelson replied, "Yes, Your Honor." The trial court then swore in the jury, and Adelson never renewed his motion to change venue. The Supreme Court of Florida said in Armstrong v. State that a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. Armstrong v. State, citing Martin v. State. Jury selection issues are deemed waived after acceptance of the jury unless the objection is renewed or the jury is accepted subject to an earlier objection. Page 20. See also Hilton v. State, holding that defendant must make a second objection before jury is sworn. Failure to lodge the second objection indicates abandonment of the initial objection. Because Adelson waived all his objections to the jury, this court should reject Adelson's first argument without reaching the merits. B. Adelson failed to comply with the Florida Rule of Criminal Procedure 3.240. Florida Rule of Criminal Procedure 3.240 says that every motion for change of venue shall be in writing and accompanied by 1. Affidavits of the movement, and 2 or more other persons setting forth facts on which the motion is based, and 2. A certificate by the movement's counsel that the motion is made in good faith. Adelson made an oral motion to change venue without providing any supporting documents. Adelson's motion, therefore, was legally insufficient. See Provenzano v. State, holding that because defendant failed to file a written motion, his change of venue argument was unpreserved. Page 21. Footnote 9. Appellate contends that the trial court erred in failing to grant his request for change of venue. However, this issue has not been preserved for appellate review because the motion to change venue was neither written as required by Florida Rule of Criminal Procedure 3.240 and requested by the judge, nor ruled upon by the trial court. Provenzano, end footnote. See also Holsworth v. State, implying that defendant's motion to change venue was legally insufficient because it failed to comply with Rule 3.240. Footnote 10. As a threshold matter, we note that appellant offers no record evidence of compliance with the Florida Rule of Criminal Procedure 3.240 paren B paren 1. However, assuming arguendo that appellant's oral motion was procedurally sufficient, we review this claim on its merits. Holsworth. Adelson also failed to file a certificate of good faith as required by Rule 3.240. The Supreme Court of Florida demands strict compliance when a motion requires a certificate of good faith. See Barnhill v. State, holding that the trial court properly denied motion to disqualify judge because counsel's certificate of good faith was insufficient. This court should affirm the trial court's ruling because Adelson's motion was legally insufficient, even though the trial court denied Adelson's motion on other grounds. See Cohen v. Mohawk, Inc. Page 22. If upon the pleadings and evidence before the trial court there was any theory or principle of law that would support the trial court's judgment, the district court is obliged to affirm that judgment. C. If this court reaches the merits of Adelson's motion to change venue, the standard of review is fundamental error. In his initial brief, Adelson argues that the standard of review is abuse of discretion. This is wrong. Adelson failed to preserve his objection to venue because he never filed a legally sufficient motion, and he never renewed his objection before the trial began. If this court considers Adelson's unpreserved argument on the merits, then Adelson has the burden to demonstrate fundamental error. See Smith v. State. Applying fundamental error standard of review where defendant failed to preserve his motion for change of venue. See also subsection 924.051 per 3 Florida statutes limiting unpreserved appellate arguments to review for fundamental error. To demonstrate fundamental error, Adelson must show that a verdict of guilty could not have been obtained without the assistance of the alleged error. Page 23. State v. Delva, quoting Brown v. State. D. Leon County residents were capable of trying Adelson's case solely upon the evidence presented in the courtroom. A defendant seeking a change of venue carries a heavy burden. He must demonstrate that the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely upon the evidence presented in the courtroom. McCaskill v. State, quoting Kelly v. State. Adelson argues that he was entitled to a change of venue under McCaskill due to the pretrial publicity surrounding his case. The defendant in Rawling v. State made the same argument unsuccessfully. Danny Rawling gained infamy by brutally murdering 5 University of Florida students in 1990. The Associated Press described Rawling as Florida's most notorious serial killer since Ted Bundy. Page 24, footnote 11. Ron Word, Florida slayer, put to death by injection, Associated Press, October 25, 2006. Despite Rawling's portrayal in the media, the Florida Supreme Court held that Rawling was properly brought to trial in Alachua County, where he murdered his 5 victims. The Supreme Court rejected Rawling's change of venue argument using a 2-prong analysis that considered 1, the extent and nature of any pretrial publicity, and 2, the difficulty encountered in actually selecting a jury. 1. The pretrial publicity surrounding Markel's murder did not prevent Adelson from receiving a fair trial. Adelson cannot meet his burden under the first prong of Rawling to demonstrate that the extent and nature of the pretrial publicity warranted a change of venue. Rawling gives trial courts 5 factors to determine whether pretrial publicity warrants a change of venue. 1. The length of time that is passed from the crime to the trial and when, within this time, the publicity occurred. 2. Whether the publicity consisted of straight, factual news stories or inflammatory stories. Page 25. 3. Whether the news stories consisted of the police or prosecutor's version of the offense to the exclusion of the defendant's version. 4. The size of the community in question. And 5. Whether the defendant exhausted all his preemptory challenges. Rawling. More than 9 years passed between Markel's murder and Adelson's conviction. In Rawling, the court found that a change of venue was unnecessary when 3½ years passed between the murders and Rawling's trial. See Rawling. Adelson failed to make a record as to whether the publicity surrounding Adelson's trial consisted of straight, factual news or inflammatory stories. Most of the prospective jurors learned about Markel's murder through professional news outlets like ABC, CNN, Fox, the Tallahassee Democrat newspaper, and WCTV, a local television station affiliated with CBS. Nothing in the record suggests that these professional news outlets said anything inflammatory about Adelson. The pretrial publicity in Foster v. State was more inflammatory than any of the media coverage surrounding Adelson's case. Page 26. Still, the Supreme Court of Florida held that Foster was not entitled to a change of venue. Foster was the leader of a group of young men in Fort Myers that called themselves the Lords of Chaos. These young men murdered a high school band teacher who caught the Lords of Chaos vandalizing a school. Foster moved to change venue because of the negative publicity leading up to his trial. As part of his motion, Foster provided newspaper articles and television broadcasts reporting his plan to go to Disney World and kill black tourists. One of these articles referred to Foster as a psychopath, Opie with a gun, and a Jekyll and Hyde type character. Another newspaper article published just 2 days before Foster's trial read, "Old Sparky's hot jolt may await Foster." The same article called Foster a redneck, racist, and a gun-crazed punk. Despite such negative publicity, the court held that the media coverage as a whole did not reach such an inflammatory level to have irreversibly infected the community so as to preclude an attempt to secure an impartial jury. Adelson also failed to demonstrate that the publicity surrounding his trial supported the state's viewpoint. Nothing in the record suggests that the major news outlets served as a mouthpiece for the police or the state attorney's office. Page 27. One prospective juror did volunteer that former prosecutor and court TV host Vinnie Politan had expressed negative views about Adelson, but this juror could not remember what Politan said. The juror also took Politan's negative view of Adelson with a grain of salt. Politan is from New Jersey. He's a prosecutor. He has opinions about a lot of people, and they're normally not positive. Adelson cannot argue that his trial occurred in a small community. According to the United States Census Bureau, Leon County had 292,198 residents in 2020. Footnote 12, U.S. Census Bureau 2020 Census Population and Housing Map, Florida. By comparison, there were 181,596 residents in Alachua County in 1990, 4 years before Danny Rawlings' trial. Footnote 13, U.S. Census Bureau 1990 Census of Population, General Population Characteristics, Florida. End footnote. If Rawlings could receive a fair trial in 1994 in Gainesville, then Adelson could receive a fair trial in 2023 in Tallahassee. Page 28. Adelson's use of preemptory challenges also undermines his argument. Adelson did not use all 9 of his preemptory strikes until the end of jury selection, when he used his leftover preemptory challenges to backstrike 2 prospective jurors. At this point, the state and Adelson had already accepted 12 jurors for the main jury. If the minds of Leon County residents were truly infected, then Adelson would have run out of preemptory challenges long before 12 jurors were seated. 2. Adelson had no difficulty in selecting a jury. Adelson cannot meet his burden under the second prong of Rawlings, which addresses the difficulty in selecting a jury. While 22 prospective jurors said they could not be fair, 30 of the prospective jurors had never heard of the Markel trial. Also, whenever a prospective juror expressed an opinion about Adelson's guilt, the trial court erred on the side of caution. Once a prospective juror has provided that opinion, it definitely skews towards their excusal. At the end of the initial screening, Adelson agreed to 58 prospective jurors for the final phase of jury selection. Page 29. E. Adelson's case was not like Manning v. State. Adelson relies on Manning v. State, one of the few cases where the Supreme Court of Florida found that a trial court abused its discretion by not granting a change of venue. The defendant in Manning was a black man accused of murdering two well-liked Caucasian deputies in Columbia County in 1976. The court described these murders as the main topic of conversation in this small rural community. At that time of the 1980 census, 35,399 people lived in Columbia County. Footnote 14, Florida Office of Economic and Demographic Research, Columbia County. End footnote. Because of the local animosity towards Manning, the public defender's office recused itself, and Manning had to be moved to a jail in another county for his safety. The court described the news coverage surrounding Manning's case as intense, adding that both the police and the prosecutor made press releases relaying their version of the deputy's murders. The court also noted the extent to which Manning's jury pool was tainted, quoting, "Every member of this prospective jury had knowledge of ex parte statements of the evidence against the accused." Page 30. Adelson's case was nothing like Manning. Tallahassee in 2023 was not a small rural community. None of the prospective jurors interviewed mentioned press releases from the police or the state attorney's office. Not every prospective juror had heard of Markel's murder or Adelson's prosecution. Also, Adelson's case did not involve the racial hostility that influenced the Supreme Court's holding in Manning. Page 31. 2. Striking the jury panel was unnecessary, and Adelson's argument is procedurally barred. Adelson argues that the trial court should have struck the entire jury pool because a few prospective jurors made comments about Adelson's case in the jury waiting room. But Adelson affirmatively accepted his jury, thereby waiving all the objections he made during jury selection. Also, the comments by the prospective jurors did not warrant striking the panel because those jurors did not mention facts that would not otherwise be presented to the jury. A. Adelson waived his argument by accepting the jury without objection. Adelson affirmatively accepted his jury without reserving his objection to the jury pool. Adelson also failed to renew his motion to strike the jury pool after the trial court swore in the jury. This court made clear in Johnson v. State that a defendant must renew any objection to the jury pool before the jury is sworn in. Appellant claims the trial court abused its discretion in denying his motion to strike this venire. This claim is not preserved for appeal because the appellant's motion was not renewed once jury selection was complete or before the jury was sworn. Page 32. See also Hayes v. State, holding that defendant waived his motion to strike the entire jury pool because defendant did not renew his objection before the jury was sworn. Because Adelson waived his objection to the jury pool, this court should affirm Adelson's conviction without considering his arguments on the merits. B. Adelson failed to comply with Florida Rule of Criminal Procedure 3.290. Florida Rule of Criminal Procedure 3.290 requires that a challenge to the panel shall be in writing and shall specify the facts constituting the grounds of the challenge. Adelson's oral motion was legally insufficient. This court recognized the importance of a written motion in Cargill v. State, holding that defendant's objection to the jury panel was not open for consideration on review because it was not in writing and untimely. Because Adelson failed to comply with Rule 3.290, his argument is either waived or unpreserved. Page 33. C. If this court reaches the merits of Adelson's argument, the standard of review is fundamental error. Adelson argues that the standard of review is abuse of discretion. Adelson is mistaken because he failed to preserve his motion to strike the jury pool and failed to file a legally sufficient motion. Adelson's argument is unpreserved. Adelson therefore has the burden of demonstrating fundamental error. See subsection 924051, paren 3 Florida statutes, limiting unpreserved arguments to fundamental error review on appeal. To demonstrate fundamental error, Adelson must show that a verdict of guilty could not have been obtained without the assistance of the alleged error. Delva, quoting Brown. D. The isolated comments of a few prospective jurors did not warrant striking the entire jury pool. Adelson moved to strike the jury pool after a handful of prospective jurors made comments about Adelson's case. The Supreme Court of Florida said in Johnson v. State that, quote, in order for the statement of one venire member to taint the panel, the venire member must mention facts that would not otherwise be presented to the jury. Page 34. Most of the prospective jurors cited in Adelson's brief only spoke about facts that were eventually addressed during Adelson's trial. One of the prospective jurors said Markel's murder happened 9 years prior. Another member of the jury pool incorrectly believed that Adelson was a federal case. Other members surmised that they had been called for a case concerning the murder of an FSU professor. One of these prospective jurors mentioned Markel's kids and a divorce. Johnson makes clear that these comments were no reason to strike the entire pool of prospective jurors. Quote, no venire member in Johnson's case mentioned a fact that would not otherwise be presented to the jury. Johnson. Adelson also complained that two prospective jurors expressed their opinion that Adelson was guilty. But the Supreme Court said in Johnson that a venire member's expression of an opinion before the entire panel is not normally considered sufficient to taint the remainder of the panel. The prospective jurors who expressed opinions about Adelson's guilt could not have poisoned the whole jury pool. One prospective juror merely mentioned to another jury pool member, I think he did it. The other prospective juror expressed his opinion that Adelson was guilty and that jury selection would last all day. Page 35. These two comments about Adelson's guilt pale in comparison to the statements at issue in Brower v. State, where a group of prospective jurors discussed hanging the defendant instead of sitting through a long trial. While the Brower court found these comments shocking, the court affirmed, holding that the defendant received a fair trial from jurors who had not acted offensively and were not otherwise tainted. Like the defendant in Brewer, Adelson received a fair trial from well-mannered, untainted jurors. Page 36. 3. Adelson's text messages reflecting normal communication were irrelevant. Adelson argues that he should have been allowed to show the jury over 400 text messages taken from his phone. None of the text messages Adelson sought to introduce into evidence contained any relevant information. Also, some of Adelson's texts contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted. In any event, Adelson suffered no harm because he testified about the content of his text messages. A. Adelson invited the error he alleges on appeal. While the trial court would not admit all of Adelson's 400-plus text messages, the court said it would consider admitting individual messages that were relevant. But Adelson never offered any individual text messages for the trial to consider. Thus, the trial court gave Adelson an avenue to enter relevant text messages, but Adelson declined to take it. This court, therefore, should reject Adelson's argument under the invited error doctrine, see Sullivan v. State, quoting, it is well-established law that where the trial judge has extended to counsel an opportunity to cure any error and counsel fails to take advantage of the opportunity, such error, if any, was invited and will not warrant reversal. Page 37. B. If this court considers the admissibility of Adelson's text messages, the standard of review is fundamental error. Adelson's initial brief argues that the trial court should not have excluded his text conversations with McBonowa, Donna Adelson, and Wendy Adelson. But Adelson's proffered texts also included conversations with his friends, business partners, and other medical professionals. While the trial court would not admit all 400-plus text messages, the court expressed its willingness to consider any relevant nuggets that went to Adelson's state of mind. Despite the trial court's offer, Adelson proceeded without proffering any individual text conversations he had with McBonowa, Donna, or Wendy, because Adelson failed to proffer any individual text messages, the trial court never ruled on any text conversations involving Magbanua, Donna, or Wendy. Adelson's argument is therefore unpreserved. See Louviere v. State, holding that defendant failed to preserve his appellate argument where defendant never obtained a clear ruling excluding evidence. Page 38, footnote 15, quoting, Louviere's argument fails because he did not preserve the issue on appeal. Defense counsel did not obtain a clear ruling on his objection to the exclusion of Louviere's testimony on the nonviolent nature of his prior convictions. Although the trial court twice stated that it would sustain an objection to any question about the nature of Louviere's prior felonies, it never had a chance to do so because defense counsel never asked the question. End footnote. Newton's v. South Florida Baptist Hospital, holding that plaintiff waived his objection by failing to obtain a clear ruling on his objection. If this court considers Adelson's unpreserved argument on the merits, it should apply the fundamental error standard of review, see Steinhorst v. State, except in cases of fundamental error, an appellate court will not consider an issue unless it was presented to the lower court. To demonstrate fundamental error, Adelson must show that the outcome of the trial would have been different had the trial court admitted Adelson's text conversations with Magbanua, Donna, and Wendy. See Everett v. State. Fundamental error is error that undermines the confidence in the trial outcome and goes to the very foundation of the case. Page 39. C. Adelson never proffered any text messages from July 2014. Adelson's initial brief argues that his text messages showed that Adelson and his alleged co-conspirators were communicating normally during and around the time of the murder. But Markel's murder occurred in July of 2014, while Adelson's exhibit of 400-plus text messages detailed conversations that occurred between June 2nd and June 7th, 2014. These texts from June 2014 corresponded to the hitman's first unsuccessful attempt to kill Markel. Adelson's attorney told the trial court he planned on doing the same thing for July 14 through 19, but Adelson never proffered any text messages from July of 2014. This court therefore should reject Adelson's argument regarding the relevance of his July 2014 text messages. See Martin v. State. Quoting, without a proffer, an appellate court cannot determine whether an error occurred, let alone a fundamental error, unquote. Page 40. D. Adelson's text messages were irrelevant. According to Adelson, his 400-plus text messages were relevant because they established reasonable doubt and demonstrated his state of mind. Adelson is wrong on both points. Generally, any evidence that could establish reasonable doubt is admissible, and a close call should be resolved in the defendant's favor as long as there is a possibility of the evidence creating a reasonable doubt, May v. State. But evidence as to immaterial matters is inadmissible for any purposes, Erb v. Carroll. Adelson could not establish reasonable doubt by showing that he texted people about immaterial matters, just because Adelson never texted Magbanua, Donna, or Wendy. Footnote 16. Besides being irrelevant, Adelson sent suspicious texts on June 7, 2014, the day after the hitmen returned to Miami after their first failed attempt to kill Markel. On that day, Adelson texted Magbanua, "Are you okay? Call me." Later that day, Wendy sent a text to Adelson saying, "What's up? Call me." To this, Adelson responded, "Sure." End footnote. About murder did not mean that Adelson was unaware of the plot to kill Markel. See May, holding that defendant could not use financial audit reports to show he never committed fraud when the proffered audits would not have detected the fraud alleged by the state. Adelson's texts were also irrelevant because they did not support his theory of defense, that Magbanua and the hitmen killed Markel in a scheme to extort Adelson. See Arroyo v. State, holding no abuse of discretion in excluding text messages that were marginally relevant and not relevant to the defendant's theory of the case. Adelson's other argument is that his text messages demonstrated his state of mind. This is wrong. Section 90.803 Florida statutes recognizes two types of hearsay statements that are relevant to demonstrate the declarant's state of mind. One, statements that prove the declarant's state of mind at a time when such state is an issue in the action, and two, statements that prove or explain the declarant's subsequent conduct. Subsection 90.803 paren 3 paren A Florida statutes. The thoughts expressed in Adelson's text messages were not relevant to any issue in the action. Adelson's text also failed to prove or explain Adelson's subsequent conduct. See Penlaver v. State. Statements admitted during the state of mind exception to the hearsay rule are properly admitted only if they involve the state of mind of the declarant and there is evidence demonstrating that the declarant acted in accord with the state of mind or intent. Page 42. The fact is that Adelson did not offer his text messages to demonstrate his state of mind. Instead, Adelson tried to use his texts to show that he had not aided Magbanua and Garcia in the plot to murder Markel. But a defendant cannot offer state of mind evidence to prove prior conduct. Chief Judge Irvin recognized in Reed v. State that a statement of the declarant's then existing state of mind is admissible to prove or explain the declarant's subsequent conduct, but not his prior conduct. Irvin, see Judge concurring, quoting Charles W. Earhart, Florida Evidence. Like Adelson, the defendant in Cotton v. State tried to use his self-serving statements to show that he was unaware of a crime. The police caught Cotton with a package containing a cocaine drop during a traffic stop. Cotton told the police that the driver had just handed him the package and that he had no idea that it contained cocaine. Cotton argued that his denial of guilty knowledge to the police came within the state of mind exception to the hearsay rule. Page 43. The 4th District Court of Appeal rejected that argument. Instead, the 4th District held that Cotton's statement was precisely the type of self-serving exculpatory statement that has been traditionally regarded as inadmissible hearsay because of his lack of reliability and trustworthiness. While Adelson's texts were not expressly exculpatory, Adelson offered his texts for the same purpose as the statements proffered in Cotton, to show that Adelson was unaware of a criminal act. But like the statements proffered in Cotton, Adelson's texts were not reliable or trustworthy evidence of Adelson's ignorance of the plot to kill Markel. E. The trial court's exclusion of the text messages did not harm Adelson. This court should affirm because the trial court's ruling did not prejudice Adelson. See subsection 924.33 Florida statutes requiring appellate courts to affirm unless an error was committed that injuriously affected the substantial rights of the appellant. The trial court's exclusion of Adelson's text messages was harmless for 4 reasons. First, Adelson testified that he reviewed every text message he sent and received between June 2 and June 7 of 2014, and none of those texts discussed Markel's murder. Page 44. The text messages themselves would have been cumulative to this testimony. See Calhoun v. State, holding that any error in excluding defendant's self-serving statements was harmless beyond a reasonable doubt where the statements were cumulative to other information elicited during the trial. See also Linnick v. State, holding that exclusion of father's testimony about defendant being a Bosnian refugee was harmless because some of this testimony was heard by the jury. Second, the texts would have likely angered the jury. Some of Adelson's texts contained racist words and references. Other texts were sexually explicit. Still others were misogynistic. The trial court's exclusion of Adelson's distasteful texts avoided their prejudicial effect. Adelson, therefore, cannot complain that he suffered prejudice due to the trial court's ruling. See subsection 924.051 paren 3 Florida statutes. A judgment or sentence may be reversed on appeal only when an appellate court determines after a review of the complete record that prejudicial error occurred. Page 45. Third, the jury heard recordings of Adelson speaking about Markel's murder after the bump. This evidence showed that Adelson preferred to speak about Markel's murder either over the phone or in person. Adelson also spoke very cautiously about Markel's murder, often using coded language. For example, Adelson had a phone call with Donna where he told Adelson that it's clear what's wanted. This TV is probably about 5. Donna's use of TV is significant because Adelson had joked that buying Wendy a TV was cheaper than hiring a hitman. Adelson knew exactly what Donna's coded language meant, and he responded, "They asked you for $5,000? Another example was Adelson's conversation with Mike Bonawa at Dolce Vita restaurant, where Adelson spoke of a horrible crime involving a gun. During this conversation, Adelson posited a hypothetical resembling Markel's murder, where the killer would rent a car and drive to Orlando to rob a McDonald's. Because Adelson was so cautious about discussing Markel's murder over the phone and in person, the jury would not be shocked to learn that Adelson avoided discussing the murder over text. Page 46. Adelson's attorney even admitted during closing arguments that it did not make any sense for a guy who was about to murder someone to go around town and advertise it. Fourth, Magbonawa's testimony crushed Adelson's claim that he was unaware of the plot to kill Markel. Around Halloween of 2013, Adelson asked Magbonawa, "Do you know anybody that can harm someone?" In response, Magbonawa said yes and kind of left it alone. Later, Adelson told Magbonawa that he wanted Wendy's husband killed. Adelson claimed that Wendy's husband was a terrible man and making his family go through a lot custody-wise with his sister. According to Adelson, this turmoil had caused his mother to stop eating and sleeping. Adelson added that his father's health was also in decline. Magbonawa said that Adelson became a little more adamant about getting this job getting done in June of 2014. Adelson initiated Markel's murder by giving Magbonawa a manila envelope containing the information Garcia would need to find Markel. Adelson took steps to ensure that his DNA and fingerprints would not be on the envelope or its contents, and he advised Magbonawa to do the same. Page 47. It was clear from Magbonawa's testimony that Adelson kept his discussion of the murder plot to a minimum and preferred to communicate about the murder in person. Magbonawa's testimony also showed that Adelson took measures to conceal his connection to Markel's murder and the hitmen. The jury, therefore, would have been unsurprised to learn that Adelson did not text about the plot to kill Markel. Page 48, Issue 4. Adelson's out-of-court statement about extortion was inadmissible hearsay. Adelson claims that the trial court should have admitted a phone call where Adelson spoke with Donna about extortion. In this call, Adelson told Donna, "I'm just telling you it's not done like that. It's not. I know for a fact it's not. It's not done like that at all. It's not done in such a nice manner." According to Adelson, this statement proved he had been the victim of extortion. Adelson's statement in this phone call was inadmissible hearsay because it was offered for the truth of the matter asserted, that Adelson had experienced extortion. Also, Adelson's statement did not fall under the state of mind exception to the hearsay rule because it described the past conduct of other people. A. The standard of review is mixed because Adelson never argued that his statement was not hearsay. When the trial court asked Adelson's lawyer why Adelson's statement was not inadmissible hearsay, Adelson's lawyer responded that the statement went to Adelson's state of mind. In other words, Adelson argued that his statement was hearsay, page 49, but subject to an exception to the general rule prohibiting hearsay evidence, footnote 18. See Sigismondi v. State, recognizing statements of a declarant's then existing state of mind as an exception to the hearsay rule, quoting section 90.803, paren 3, paren A, paren 2, Florida statutes, end footnote. But on appeal, Adelson makes an additional argument. His statement was not hearsay because it was not offered for the truth of the matter asserted. This argument is unpreserved because Adelson did not raise it in the trial court, see Reynolds v. State, holding that defendant failed to preserve appellate arguments that statements were not offered for the truth of the matter asserted when defendant did not make that argument in the trial court. Adelson's argument That his statement was not hearsay is subject to fundamental error review. See subsection 924.051 paren 3 Florida statutes, limiting unpreserved arguments to review for fundamental error. This court should review the trial court's rejection of Adelson's state of mind argument for abuse of discretion. A court abuses its discretion when no reasonable person would take the position of the trial court on a matter concerning any findings which are supported in the record. Harris v. State. Page 50. B. Adelson's statement alluding to extortion was hearsay. Adelson argues that his statement alluding to extortion was not hearsay because it was not offered for the truth of the matter asserted. Adelson is wrong. Adelson wanted the jury to believe his statements about extortion was true, so his statement was hearsay. This court recognized in Chapman v. State that if an out-of-court statement is offered in court to prove the truth of the facts contained in the statement, it is hearsay. Quoting Charles W. Earhart, Florida Evidence. C. Adelson's remarks about extortion did not fall within the state of mind exception to the hearsay rule. According to Adelson, his statement about extortion fell under the state of mind exception to the hearsay rule. Adelson's argument fails for 3 reasons. First, Adelson's statement did not fall under the state of mind exception because the statement did not reflect Adelson's mental or physical state. Section 90.803 paren 3 allows hearsay evidence that shows the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health. Page 51. Subsection 90.803 paren 3 paren A Florida statutes. Instead of offering his statement to reflect his state of mind, Adelson offered his statement to prove that Garcia and Magbanua extorted him. Second, Adelson wanted to use his statement to show he had been extorted in the past, but the state of mind exception to the hearsay rule only encompasses future conduct, not prior conduct. See Reed. Urban C.J. concurring, a statement of the declarant's then existing state of mind is admissible to prove or explain the declarant's subsequent conduct, but not his prior conduct, quoting Charles W. Earhart, Florida Evidence. See also R.J. Reynolds Tobacco v. Hamilton. A hearsay statement which recounts observations made previously is by definition an after-the-fact statement of memory and expressly excluded from the state of mind exception, citing 90.803 paren 3 paren B Florida statutes, prohibiting admission of any after-the-fact statement of memory or belief to prove the fact remembered or believed unless it relates to declarant's will. Page 52. Third, Adelson could only use the state of mind exception to explain his own conduct, not the conduct of another. Adelson, therefore, could not use his own out-of-court statement to show that Garcia or Magbanua extorted him. See Shepard v. United States, holding that victim's statement, Dr. Shepard has poisoned me, did not fall within state of mind exception. Evidence of the declarant's state of mind is only admissible to explain the declarant's actions, not as proof of an act committed by someone else. See also Cybers v. State. The courts of this state have repeatedly held that out-of-court statements cannot be used to prove the state of mind or motive of someone other than the declarant. D. Excluding Adelson's phone call did not prejudice him. Adelson must demonstrate that the trial court's ruling excluding his phone call was an error that injuriously affected his substantial rights. See subsection 924.33 Florida statutes. Adelson fails to meet this burden for 4 reasons. First, Adelson's statement to Donna suggested he was familiar with the concept of extortion, not that he had been the victim of extortion. Page 53. But most people are familiar with how extortion works, even if they have never been extorted. Adelson's statement, therefore, was marginally relevant at best. Second, Adelson was allowed to testify about the contents of his phone call with Donna. Adelson told the jury that he advised Donna that it's not done this way. I know for a fact, and I'm 99% sure it was what I thought it was. Third, the jury heard Adelson make an almost identical statement to Donna in one of the phone calls that the state published. The jury heard the state's call R, where Adelson and Donna discussed the bump. In that call, Adelson told Donna, "I actually do know how these things are done, and that was the same thing that I said. It's not done like this." When Adelson took the stand, he explained the above statement. According to Adelson, he meant that it's not the same people that extorted me that are extorting Donna. It's clearly not the same as the first extortion. Fourth, other phone calls between Adelson, Magbanua, and Garcia disproved Adelson's story about being extorted. After the undercover FBI agent approached Donna, Adelson called Magbanua and explained that he believed Donna was being blackmailed. Page 54. During this conversation, Adelson brainstormed with Magbanua as to who might blackmail Donna, but Adelson never said anything that implied he had been extorted too. Later, Adelson called Magbanua to tell her about a birthday present Adelson had left for Garcia. Adelson said, "If you don't think it will cause anything, you can tell him it was from me when he opens up the present." In another call between Adelson and Magbanua, Adelson revealed that he was aware but not surprised that Katie's baby daddy, Garcia, called the undercover FBI agent on Adelson's behalf. In a subsequent phone call, Magbanua told Garcia, "I told Adelson like you'd help him. You know, I'll try to help out." Garcia replied, "You know what? I'll take care of it." Later, Adelson called Magbanua to let her know that the undercover agent was a pot-bellied pig. In this call, Adelson asked Magbanua, "You know what a pig is?" These phone calls did not depict Adelson interacting with his extortionists. Instead, these calls revealed that Adelson, Magbanua, and Garcia were co-conspirators that cooperated to determine the identity of the undercover FBI agent. Page 55. Issue 5. Adelson's cumulative error argument fails because his other arguments are procedurally barred, meritless, or both. Adelson argues that the alleged errors in his 4 other arguments resulted in a cumulative error that deprived Adelson of a fair trial. But all of Adelson's other arguments are procedurally barred, meritless, or both. Outside of his 4 main arguments, Adelson alleges no additional errors that affected his trial. Adelson's claim of cumulative error, therefore, necessarily fails. See Alsager v. State, where the alleged errors urged for consideration in a cumulative error analysis are individually either procedurally barred or without merit. The claim of cumulative error also necessarily fails, quoting Bush v. State, Israel v. State. Page 56. Conclusion. Any Florida jury would have convicted Charles Adelson for effectuating the murder of Daniel Markel. Adelson was an essential link between Markel and the man who killed him, Sigfredo Garcia. Catherine Magbanua was the other essential link between Garcia and Markel, and her testimony explained how Adelson was the driving force that caused Markel's death. Adelson's text messages and phone calls could not have changed the outcome of his trial. This court should affirm Adelson's convictions for first-degree murder, conspiracy to commit murder, and solicitation to commit murder.
Deep. Very serious.
You may recall that in its answer brief, the state of Florida argued that the majority of the arguments raised by Michael Offerman, the appellate attorney for Charles Adelson, were waived, and they were not properly preserved at the trial level by Dan Rochbaum and his team. So now we get to hear Michael Offerman's response to that counter-argument from the state in what is called the reply brief in the appeal for Charles Adelson. After the reply brief has been filed, the next thing in the process is for the appellate court to decide whether it's going to hold oral arguments in the case or not. In a case like this, it is likely that there will be oral arguments, and then we'll just have to wait for an opinion. All right, here we go. Here's Ed.
The District Court of Appeal, First Appellate District of Florida. Charles Adelson, Appellant v. State of Florida. Michael Offerman, Laura Cornell Niles. Argument and citations of authority. The state's answer brief attempts to avoid the merits of Appellate Adelson's constitutional claims by failing to engage with the fundamental legal principles that underlie his arguments. Much of the state's discussion focuses on minor procedural points or characterization of isolated facts rather than confronting the broader constitutional concerns at stake, namely the right to a fair trial by an impartial jury and the right to a fair and complete presentation of a defense. The state's lack of substantive engagement with these core issues exposes the weakness of its arguments. Consequently, the state's brief does not demonstrate a sufficient basis for affirming the rulings that impacted the fairness and reliability of the proceedings below. For these reasons, each issue is addressed in turn with careful attention to the record and the law. 1. The trial court erred by denying Appellant Adelson's motion for a change of venue. Appellant Adelson continues to rely on the argument as outlined in the initial brief regarding Claim 1. Appellant Adelson maintains that after attempting to select a jury, it was clear that it would not be possible to convene a fair and impartial jury because of the extensive pretrial publicity in Tallahassee. The trial court's error in failing to change the venue violated Appellant Adelson's rights under the United States and Florida Constitutions, see U.S. Constitution Amendment 6, Article 1, and subsection 16, Florida Constitution, see also United States v. Cabrales. Quoting, the Constitution safeguards the defendant's venue right. The state argues that Appellant Adelson waived his venue argument by accepting the jury without objection. In reply, Appellant Adelson relies on Manning v. State. Despite the state's assertion that Adelson's case was nothing like Manning, in that case, the Florida Supreme Court reversed on the venue issue where, quoting, the defendant did not exhaust his preemptory challenges and accepted the jury without renewing his motion for change of venue. In fact, defense counsel Robert Markel, prior to accepting the jury, stated, quote, it would appear to us that we have a fair and impartial jury here. Nonetheless, the Florida Supreme Court held that the motion for change of venue in this case was amply supported by evidence which established that the community was so pervasively exposed to the circumstances of this incident that the defendant could not secure a fair and impartial trial in Columbia County. The court cautioned, each case must be judged on its own merits as to whether under the circumstances the inhabitants of the community are so infected by knowledge of the incident and accompanying prejudice that jurors from the community could not possibly try the case solely on the evidence presented in the courtroom. Further, because our state and federal constitutions guarantee to criminal defendants a right to a fair trial by an impartial jury, the venue error is structural. That is, the denial of the motion to change venue is the injury itself and affects every subsequent moment of trial. The state's procedural argument is therefore incorrect as a matter of law. While it is preferable to renew the objection at the end of jury selection, renewal was not required here, just as it was not in Manning. Additionally, the state argues that Appellant Adelson's oral motion for change of venue was legally insufficient because Florida Rule of Criminal Procedure 3.240 requires the motion to be submitted in writing. Notably, in both cases cited by the state in support of this assertion, the Florida Supreme Court reached the merits of the venue argument. See Provenzano v. State, Holsworth v. State. Thus, Florida law does not require strict technical compliance with Rule 3.240 for an appellate court to review a venue ruling where the trial court was aware of the objection and denied relief, i.e., what matters is whether the trial court was presented with the issue and the opportunity to rule on it. Here, the trial court expressly entertained the oral motion, asked a question regarding counsel's suggested alternative venue, and proceeded to trial knowing that Appellant Adelson contended a fair jury could not be drawn from Leon County. Appellant Adelson asserts that appellate courts retained the discretion and, in appropriate cases, the obligation to reach the issue where fundamental fairness is implicated. The situation is directly analogous to the scenario described in Provenzano. Appellant contends that the trial court erred in failing to grant his request for change of venue. However, this issue has not been preserved for appellate review. The trial court granted leave to file an oral motion for change of venue on the first day of trial. The motion was taken under advisement with the condition that a written motion following shortly thereafter. No written motion was ever filed. This allegation has not been preserved for appellate review because the motion to change venue was neither written, as required by Florida Rule of Criminal Procedure 3.240 and requested by the judge, nor ruled upon by the trial court. We choose to address the substantive aspects of this issue, however, to allay any fear that appellant did not receive a fair trial. Just as in Provenzano, the concern here goes to the core constitutional guarantee of an impartial jury. Venue is not a technical or discretionary procedural matter. It is a structural safeguard. See Urban v. Dowd. When the record demonstrates a credible risk that a defendant was tried before a jury drawn from a community that had already formed a consensus as to his guilt, as it does here, the appellate court may and should consider the merits even if a procedural rule was imperfectly followed. Unlike other claims that may be forfeited by inaction, pretrial publicity and venue issues implicate the fundamental right to a fair trial under both the United States and Florida constitutions. When fundamental fairness is at stake, appellate courts routinely review such claims to ensure confidence in the verdict and in the judicial process itself. See Holsworth v. Provenzano. This court has a duty to review the record in its entirety in reviewing this claim, see Singer v. State. In quoting, in determining whether error was committed in the denial of the motion for change of venue, we are not limited to consideration only of the motion and traverse and the matters submitted in support thereof. We are permitted to consider the whole record and have done so, unquote. The record shows pervasive, community-wide prejudice born from nearly a decade of sensationalized local reporting, repeated discussions which tied the case to the identity of the community and prospective jurors who either acknowledged bias or lied to conceal it, with some openly expressing a belief in guilt in the jury assembly room. This was not sporadic exposure, it was saturation. The state asserts that the pretrial publicity in Foster v. State was more inflammatory than any of the media coverage surrounding Adelson's case. The record does not support that characterization. As an initial matter, the pretrial publicity in Foster occurred in a pre-digital media era between 1996 and 1998, when coverage was limited to newspapers and scheduled television broadcasts. Additionally, unlike the defendant in Foster, who was tried around 2 years after the murder, the publicity in appellant Adelson's case spanned 9 years, directly involved the local university community, and repeatedly promoted a narrative of the Adelson family as architects of a long-running plot. Simply put, the publicity in this case is materially different in degree, duration, and depth of local impact than the publicity at issue in Foster. The publicity in appellant Adelson's case was not merely extensive, it was sustained, locally concentrated, narrative-driven, and personal. For nearly a decade before trial, the media repeatedly framed the case in terms of community grievance, academic loss, and the moral outrage of a murdered professor at a beloved local university. The coverage did not simply report developments, it amplified the exposure through podcasts, documentaries, social media commentary, and community forums, effectively intertwining the tragedy with a core civic identity of Leon County. Leon County residents did not simply recall the case, they had lived with it, discussed it, theorized about it, and absorbed into a shared cultural understanding of a local tragedy. That is precisely the type of saturation that Irvin, Shepard, McCaskill, Murphy, and Manning identify as such a pervasive nature that it threatens impartiality. The state also asserts that if Danny Rawling could receive a fair trial in 1994 Gainesville, then Adelson could receive a fair trial in 2023 Tallahassee. Again, appellant Adelson respectfully disagrees. The state's reliance on Rawling overlooks the fundamental difference between the pre-digital media landscape of 1994 and the pervasive, self-amplifying media environment of 2023. In other words, the media environment of 1994 is simply not comparable to the media ecosystem of 2023. In Rawling, pretrial publicity occurred almost entirely through traditional news platforms such as local newspapers, nightly broadcasts, and limited national reporting. In 1994, once the newspaper was folded and the television was turned off, the story ended for the day. As such, coverage was episodic and finite. There was no 24-hour social media commentary, no podcasts revisiting the case, no algorithms sending repeated reminders, no discussion threads allowing community members to reinforce one another's views, and no streaming platforms releasing case-related content that are accessible on demand. The publicity ended at the edges of the printed page and the conclusion of the evening broadcast. It did not follow jurors home on their phones, computers, or social media feeds. It did not regenerate or amplify itself and was not algorithmically targeted to continuously reinsert the case into public consciousness. Here, by contrast, at the time of appellant Adelson's trial, coverage of Dan Markel's murder had been continuous for nearly a decade and had proliferated across digital platforms that did not exist in 1994, including streaming documentaries, podcasts, YouTube commentary channels, Reddit true crime communities, and numerous social media platforms. Potential jurors reported drawing information from each of these sources and others, demonstrating the extraordinary reach and persistence of the coverage. Potential jurors in 2023 could not simply avoid coverage by not reading the newspaper or watching television. Exposure was persistent, shareable, and algorithmically reinforced, making prejudgment far more likely and far more difficult to screen out than in 1994. The qualitative difference in exposure is profound, and Rawling does not resolve it. The state asserts that the pretrial publicity did not originate either from the police or the state attorney's office. Appellant Adelson respectfully disagrees, but more critically, this argument misunderstands the constitutional inquiry. The question is not who lit the fuse, but how completely the fire spread. What matters is the degree of saturation, the tone of the coverage, and its effect on the venire. And the effect here was unmistakable. Here, the coverage indisputably favored the state's narrative. Voir dire revealed a community where the presumption of guilt had already been absorbed as common knowledge. 53 of 54 prospective jurors who had formed an opinion believed appellant Adelson was guilty. That is not a neutral starting point. That is a verdict delivered by the community before the trial even began. Whether the initial spark came from a press conference by the state attorney or a local police, a podcast, documentary, or online commentary is irrelevant. What matters is that the prejudice was deep, widespread, and outcome-directing. See McCaskill. The test for determining a change of venue is whether the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely upon evidence presented in the courtroom. The state argues that appellant Adelson's use of peremptory challenges somehow undermines the showing of community prejudice, asserting that Adelson's use of peremptory challenges also undermines his argument. Adelson did not use all 9 of his peremptory strikes until the end of jury selection, when he used his leftover peremptory challenges to back strike 2 prospective jurors. At this point, the state and Adelson had already accepted 12 jurors from the main jury. If the minds of Leon County residents were truly infected, then Adelson would have run out of peremptory challenges long before 12 jurors were seated. This argument is both unsupported in law and illogical in practice. First, peremptory challenges are not the mechanism for curing a tainted venire. Once a trial court denies a motion to change venue, as explained above, the injury is structural because the defendant is then forced to select a jury from a pool already exposed to prejudicial influence. Moreover, the law does not require a defendant to expend peremptory strikes in a particular order, under a particular strategy, or at a particular pace. Second, the state's premise is factually flawed. The voir dire record shows that more than 4 prospective jurors admitted to having already formed an opinion and believed appellant Adelson was guilty before hearing evidence. The relevant inquiry is the condition of the venire as a whole, not the sequence in which counsel exercised peremptory strikes. Third, the state's assertion misunderstands the role of peremptory challenges entirely. Peremptory challenges are used to remove individual jurors. They do not and cannot remedy the systemic problem of venire infected by pervasive pretrial publicity. No number of successful peremptory challenges can cure a fundamentally biased jury pool. Additionally, appellant Adelson exercised all of his peremptory challenges. Despite this, of the 12 jurors who actually sat in judgment of him, 8 had media exposure to the case in some manner. The problem here is not that appellant Adelson failed to remove a particular juror. It is that he was forced to pick a jury from a community where guilt was already the dominant assumption. That is the very harm that a change of venue is designed to prevent. The state claims that Adelson cannot argue that his trial occurred in a small community. Appellant Adelson respectfully disagrees. Although the state cites census figures to compare Tallahassee's population to Gainesville's population, community size for venue purposes is not measured by raw population numbers, but by the likelihood that members of the community share exposure to the same news sources and public narrative. See Shepard and McCaskill. More importantly, the characterization of Tallahassee as a small community comes not from appellant Adelson, but from the trial court itself. In granting defendant Charles Adelson's unopposed motion for protective order, the trial court expressly found the disclosure of these discovery materials would be big news in this small community, potentially infecting the entire jury pool, even those who at this point may be acceptable jurors. Those without an opinion at this time may form an opinion, thereby reducing the jury pool drastically. Thus, the trial court recognized precisely what appellant Adelson argues, that Tallahassee is a small community where news regarding this case spreads quickly, is widely discussed, and such news has the capacity to contaminate the entire venire. The state cannot now claim that Tallahassee is too large to raise concerns about community saturation when it previously relied on the small community nature of Leon County to justify restricting public access to discovery to avoid infecting the jury pool. The trial court's finding regarding Tallahassee as a small community also underscores a key point in the venue analysis. This case was not just known in Tallahassee, it mattered to Tallahassee. That is the defining characteristic of a change of venue motion requiring relocation regardless of population size. Accordingly, the state's attempt to dismiss the small community concern is both inconsistent with the record and contradictory to its own prior litigation posture, where the prosecutor stated on the record that the state did not oppose appellant Adelson's motion for a protective order because its main concern was to be able to try this case in Tallahassee, and therefore restricting media access to certain discovery material was warranted. In short, the trial court recognized the risk. The state did too. The voir dire record confirms that the risk materialized. The state did not respond in its answer brief to appellant Adelson's argument regarding the 2 prospective jurors who misrepresented their impartiality to the court and parties during voir dire. This silence is telling. The state's answer brief contains no rebuttal to the following undisputed facts in the record. 1. A prospective juror affirmatively stated that he had no opinion about the case, yet had previously posted on social media that if he were the parent of the victim, he would want to kill co-conspirator Sigfredo Garcia. 2. Another juror represented that he had not formed an opinion regarding appellant Adelson's guilt, but was overheard in the jury assembly room stating he's guilty in the presence of other potential jurors. These are serious misrepresentations that directly undermine the integrity of the jury selection process. They reflect exactly the scenario the case law describes, where pretrial publicity is so pervasive that jurors may profess impartiality in the courtroom while holding fixed opinions outside of it. See Patton v. Yount. Quoting, adverse pretrial publicity can create such a presumption of prejudice in a community that the jurors' claims that they can be impartial should not be believed. This point is particularly significant because it shows that at least 2 prospective jurors affirmatively concealed their true views when questioned about their impartiality. When jurors misrepresent their opinions in court, the reliability of the entire voir dire process is called into question. If 2 prospective jurors were willing to deny previously held and expressed beliefs regarding appellant Adelson's guilt, it is entirely reasonable and legally relevant to conclude that other biased jurors may have been seated despite expressing assurances of neutrality. This is the heart of the venue issue. The constitutional harm lies not only in the pretrial publicity, but in the demonstrated inability of voir dire to screen out its effects. The state's decision not to address these jurors in its answer brief underscores this point. If the state believed these incidents were insignificant, it would have said so. Its silence operates as a tacit acknowledgement that these facts powerfully undermine its claim that an impartial jury was selected in Leon County. The record reflects a community atmosphere so infused with belief in appellant Adelson's guilt that some jurors felt compelled to conceal their prejudgment in order to serve. As the United States Supreme Court has recognized, our system of law has always endeavored to prevent even the probability of unfairness. See Shepard, quoting the language of Justice Black for the court in re Murchison. With his life at stake, it is not requiring too much that petitioner be tried in an atmosphere undisturbed by so huge a wave of public passion and by a jury other than one in which 2/3 of the members admit, before hearing any testimony, to possessing a belief in his guilt. See Urban, citing Strobel v. State of California, Shepard v. Florida, Moore v. Dempsey. These principles apply in full force here. The law strives to avoid even the probability of unfairness, and a trial cannot be fair when the community has already reached a verdict before a single piece of evidence is presented. The threat to fairness becomes even greater where prospective jurors conceal their preformed beliefs during voir dire in such circumstances as here. A change of venue was necessary to protect appellant Adelson's constitutional rights. Accordingly, a new trial is required. 2. The trial court erred by denying appellant Adelson's motion to strike the Venire panel after several potential jurors reported to the court and the parties that other potential jurors were having conversations about the case after being instructed not to do so. As to Claim 2, appellant Adelson continues to rely on the argument in the initial brief. The record reflects multiple independent reports that prospective jurors were discussing appellant Adelson's case, including expressions of guilt after being specifically instructed not to do so. Under these circumstances, the trial court's refusal to strike the Venire panel was an abuse of discretion. The state's argument that appellant Adelson affirmatively accepted his jury without objection ignores the multiple contemporaneous motions and renewals of the motion to strike the Venire throughout voir dire. Defense counsel moved repeatedly to strike the panel as more reports of improper discussions and premature judgments emerged. This is not a case where a single early objection was abandoned. Rather, the defense renewed its objection multiple times, each time prompted by newly revealed misconduct within the panel. The record plainly reflects an ongoing, preserved objection that a particular section of the Venire was tainted. The state's reliance on Johnson v. State and Hayes v. State is unpersuasive. In those cases, the defendants failed to renew or maintain their objections after voir dire concluded, leaving open the possibility that the objections had been abandoned. Here, by contrast, defense counsel objected and renewed the motion multiple times during voir dire while the prejudice was unfolding, and the trial court expressly ruled on each one. There was nothing further to renew after the court denied the motions and proceeded to trial. See also Caratorelli v. State. Quoting, under our cases, the preservation of a challenge to a potential juror requires more than one objection. Here, defense counsel did make more than one objection motion, and therefore the motion was renewed before the jury was sworn, i.e. multiple times during voir dire. Appellant Adelson also notes that the circumstance in this case does not pertain to the preservation of a challenge to one specific potential juror, but to an entire section of jurors who were exposed to impermissible content or committed misconduct themselves. Relatedly, the state's procedural argument under Florida Rule of Criminal Procedure 3.290 also fails. The state argues that Appellant Adelson's oral motion was legally insufficient because Adelson failed to comply with Rule 3.290. Rule 3.290 states, the state or defendant may challenge the panel. A challenge to the panel may be made only on the ground that the prospective jurors were not selected or drawn according to law. Challenges to the panel shall be made and decided before any individual juror is examined unless otherwise ordered by the court. A challenge to the panel shall be in writing and shall specify the facts constituting the ground of the challenge. Challenges to the panel shall be tried by the court. Upon the trial of a challenge to the panel, the witnesses may be examined on oath by the court and may be so examined by either party. If the challenge to the panel is sustained, the court shall discharge the panel. If the challenge is not sustained, the individual jurors shall be called. Plainly, Appellant Adelson did not assert a challenge to the panel as contemplated by the rule. The purpose of the rule is to address irregularities in the formation of the jury panel itself, such as the systematic exclusion of a class of persons based on race, sex, ethnicity, religion, or similar characteristics. See generally Gordon v. State. Quoting, while defendants are not entitled to a particular jury composition, jury wheels, pools of names, panels, or veneries from which jurors are drawn must not systematically exclude distinctive groups in the community and thereby fail to be reasonably representative thereof. Simmons v. State. It is crystal clear, that in making up the jury list there was an intentional and systematic exclusion of common laborers as a class. Unquote. By contrast, Appellant Adelson's motion sought to strike a portion of the venire, specifically jurors 51 through 102, not because of any illegality in the panel's formation, but because those jurors either 1. Violated the court's directive not to discuss the case, or 2. Were exposed to comments from other prospective jurors who violated the court's directive not to discuss the case. It was not possible to make the motion to strike the panel or rule upon it before any individual juror is examined because it was the voir dire examinations themselves that revealed the misconduct. Accordingly, Rule 3.290 was not implicated, and Appellant Adelson was not required to submit the motion in writing to preserve the issue for appellate review. Additionally, the grounds for the motion stated by the trial counsel were factually specific and made on the record, which ensured that the trial court and opposing counsel were aware of the factual basis for the challenge. The trial court and state both responded to the substance of the motion, leaving no doubt it is properly before the court. See Steinhorst v. State. Quoting, in order for an argument to be cognizable on appeal, it must be the specific contention asserted as legal ground for the objection, exception, or motion below, unquote. Accordingly, this court may review the issue on appeal. See State v. Calvert. Quote, the purpose of the contemporaneous objection rule is to place the trial judge on notice that error may have been committed and provides him an opportunity to correct it at an early stage of the proceedings. Objections may be preserved on the basis that their purpose is clear from the context, unquote. The trial court abused its discretion when it refused to strike the panel of tainted jurors. The issue was preserved, as explained above, and thus the correct standard is abuse of discretion. Nonetheless, Appellant Adelson contends that the error amounts to fundamental error because it cannot be said that the guilty verdict could have been obtained without the error. CFB v. State, quote, the sole exception of the contemporaneous objection rule applies where the error is fundamental, unquote. In other words, even if this court were to apply fundamental error review, the result is the same. An error is deemed fundamental when it goes to the foundation of the case or the merits of the cause of action and is equivalent to a denial of due process, JB v. State, citing State v. Johnson. The pervasive nature of the improper discussions here meets that standard. The state minimizes what occurred by labeling the misconduct as isolated comments. The record tells a different story. Jurors repeatedly reported that other potential jurors were openly discussing the case, sharing details, and expressing opinions of guilt despite explicit court instructions not to do so. At least 3 distinct prospective jurors confirmed these violations, each describing different speakers, conversations, and opinions. One juror stated that people were discussing the case all day. Another heard someone say, "I think he did it." This was not a single rogue remark. It was a pattern of disobedience and premature deliberation across multiple potential jurors. In response, the trial court reiterated its admonition to the panel and removed a few identified jurors for cause. But, as defense counsel correctly observed, this did not cure the problem. We have no idea who this young man said was within earshot of, or how many others were affected. In short, nothing in this record supports the state's assertion that Appellant Adelson received a fair trial from well-mannered, untainted jurors. When misconduct permeates the venire to this degree, the court's admonition could not restore the presumption of impartiality that the Sixth Amendment requires. Given repeated reports of improper juror discussions and admissions of guilt opinions, the trial court's decision to proceed with the tainted venire was unreasonable. The court recognized the problem, warned the panel, and removed some jurors, but declined to address the broader contamination. That half measure failed to safeguard Appellant Adelson's constitutional right to an impartial jury. Allowing a tainted jury panel to remain intact, violated Appellant Adelson's constitutional right to a fair and impartial jury and deprived him of his right to a fair trial. See U.S. Constitution Amendments 5 and 14, Article 1, Subsection 9, Florida Constitution. Appellant Adelson's convictions must be reversed and remanded for a new trial before an untainted jury. 3. The trial court erred by excluding defense-proffered text messages that would have shown Appellant Adelson and other alleged co-conspirators communicating normally during the time leading up to Dan Markel's murder to rebut the state's contention that Appellant Adelson and alleged co-conspirators were making phone calls about the murder during the relevant time period. As to Claim 3, Appellant Adelson relies on the argument outlined in his initial brief. The state responds that none of the text messages Adelson sought to introduce into evidence contained any relevant information. Also, some of Adelson's texts contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted. In any event, Adelson suffered no harm because he testified about the content of his text messages. Appellant Adelson respectfully disagrees with each of these points. The state's claim that Appellant Adelson invited the error because he did not proffer individual text messages mischaracterizes both the record and the nature of the trial court's ruling. The record reflects that defense counsel sought to introduce the messages collectively as a single exhibit, offered not for the truth of the matters asserted, but to rebut the state's multiple inferences that phone communications between Appellant Adelson and others around the time of the murder related to the murder itself. Because the state presented its phone call evidence as a pattern or composite rather than individually, the defense needed to enter the text messages in the same collective format to provide a meaningful rebuttal. Counsel expressly articulated the relevance of the messages, which was to demonstrate that Appellant Adelson and the alleged co-conspirators were communicating normally about work and daily life rather than criminal activity. That the trial court suggested to the defense that it could, instead of offering the composite exhibit, enter specific text messages, and that defense counsel ultimately declined to do so, did not invite the error, as suggested by the state. Invited error occurs when a party induces the trial court into error or affirmatively agrees to the challenged ruling, see White v. State, holding that the defendant cannot take advantage on appeal of the situation he created at trial, citing McCrae v. State. The trial court's statement that, if there are portions again that are specifically relevant to negating either the motive or any of the elements of the charges and are not hearsay, as argued by the defense, I will consider those separately. But as a composite, on the whole, the 403 issues, the relevance and hearsay issues, I believe, compel me to deny their admission. Transcript 1593 did not transform the exclusion into an invited error. Once the trial court excluded the composite on hearsay, relevance, and prejudice grounds, further individual offers would have been futile. Simply put, invited error occurs when a party induces or acquiesces to a ruling they later contest, which is not the situation here. The purpose of introducing the composite exhibit of text messages was to show the pattern of ordinary, non-criminal communication between Appellant Adelson and the alleged co-conspirators during the critical time period surrounding Dan Markel's murder. The exhibit was not offered to prove the truth of any statements, but rather to demonstrate that, contrary to the state's suggestion, the communications consisted of routine discussions about work, family, and personal matters, and did not indicate planning, coordination, or awareness of the murder of Dan Markel. That alone established the relevance of the evidence. It directly rebutted the state's inference that phone communications during the same time frame were conspiratorial or connected to the murder, evidence that tends to disprove an essential element of the state's theory or that creates a reasonable doubt regarding participation in a crime is squarely within the scope of relevant evidence. See subsection 90.401 Florida statutes. In response to the state's assertion that the evidence lacked relevance, Appellant Adelson turns to the well-reasoned decision of the 2nd District Court of Appeal in Mateo v. State. There, the 2nd District explained, Florida law is clear that where evidence tends in any way, even indirectly, to establish a reasonable doubt of defendant's guilt, it is error to deny its admission. Rivera v. State. This principle is based in part on the U.S. Supreme Court's holding that few rights are more fundamental than that of an accused to present witnesses in his own defense. Chambers v. Mississippi. Thus, a general proposition, any evidence that tends to support the defendant's theory of defense is admissible, and it is error to exclude it. Dean v. State, Vanier v. State. Further, while the defense is bound by the same rules of evidence as the state, the question of what is relevant to show a reasonable doubt may present different considerations than the question of what is relevant to show the commission of the crime itself. Vanier. Thus, in Vanier, the court held that it was error for the trial court to have excluded evidence of letters written by the victim that tended to show that she was depressed and thus arguably supported the defendant's theory that the victim was not murdered but instead committed suicide. Similarly, in Bertram v. State, this court held that it was error for the trial court to refuse to permit the defendant to cross-examine a witness as to prior altercations between the defendant and his father when the theory of defense was that the father had set up the defendant in retaliation for the altercations. Likewise, in Dean, the court held that it was error for the trial court to refuse to permit the defendant to introduce a pawn slip when the defense theory was that the person who pawned the jewelry rather than the defendant was the perpetrator of the robbery. In this case, Mateo's theory of defense was that the jail officials were biased against him because he had been vocal about jail conditions in the past, and that they made up the story about the lunch tray and the shank to cover up their misconduct. The audio tape in question does provide some evidence that supports this theory. The jail employee indicated that Mateo was placed in lockdown based solely on his past behavior and that she would be moving Mateo to a different facility so that the supervisor won't go after him. These statements, made by an employee of the jail where the incident occurred, provide at least some evidence of a pre-existing animosity between Mateo and the jail officials. This animosity, in turn, could provide evidence of a bias against Mateo by the jail officials that might affect the jury's assessment of their credibility and or their recollections and interpretations of the events supporting the charges. Thus, the audio tape was relevant in that it tended to support Mateo's defense, and the trial court erred in excluding it from evidence. See Mateo. Applying the principles explained in Mateo, the trial court in this case similarly erred in excluding evidence that appellant Adelson regularly communicated with the alleged co-conspirators and that they were communicating normally about work and daily life rather than conspiring to commit the murder during the time leading up to the murder. Just as the excluded evidence in Mateo tended to show bias and animosity that could support the defendant's theory of defense, the evidence of appellant Adelson's normal communications was directly relevant to appellant Adelson's theory that he did not conspire with others to commit the crime, but was later blackmailed into paying money to Catherine Magbanua, who in turn paid the killers. Critically, some evidence supporting the theory of defense is sufficient to warrant admission. Mateo. Here, even modest evidence that appellant Adelson communicated normally during the relevant time period was enough to support the defendant's claim that appellant Adelson was 1. Not involved in soliciting Magbanua, Rivera, or Garcia to commit the murder, 2. Conspiring with Magbanua to commit the murder, or 3. Guilty as a principal to the murder itself. By presenting the jury with the substance of the messages, the defense sought to show a lack of pattern of criminal intent and to illuminate appellant Adelson's state of mind. In urging the trial court to admit the exhibit, defense counsel articulated the relevance of the messages to appellant Adelson's state of mind. His state of mind is not that he's going to commit a murder. His state of mind is his normal, everyday activity. My life is the same as it was in February. I'm not talking about a murder. I'm not worried about anything. I'm living my life. That's what these text messages show. The state also contends that the exclusion of the messages did not prejudice appellant Adelson. Respectfully, appellant Adelson submits otherwise. By barring the defense from presenting this evidence, the trial court deprived appellant Adelson of the opportunity to fully present his defense and to challenge the prosecution's narrative that he and Magbanua were communicating about the murder. Like the evidence in Mateo, this information was not peripheral. It was central to the jury's assessment of reasonable doubt and to appellant Adelson's constitutionally protected right to present a complete defense. Accordingly, the trial court's ruling constitutes reversible error. The state argues that the composite text message exhibit contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted. Further, the state argues that the texts would have likely angered the jury. But this misses the point. Appellant Adelson deliberately sought the admission of the exhibit, fully aware that some messages contained offensive language. Footnote 5. During the trial, the following was said. The court. The other concern I have with this is it would possibly cast even your client in a bad light. It was good seeing you, Negro. I think he called Miss Magbanua at one point a strong black woman. I don't know if there's any references to the N-word or other things in here. There were with other witnesses, but this is going to be a look at your own risk. Mr. Rashbaum. I understand, Your Honor. The Court. Please review to find the most relevant nuggets to go to the actual state of mind. Mr. Rashbaum. Okay, they all go to state of mind. End footnote 5. He understood the potential for embarrassment, yet chose to try to introduce the messages because their probative value, showing normal, everyday communications and rebutting the state's inference of criminal intent, far outweighed the risk of discomfort or prejudice to himself. In other words, Appellant Adelson made a strategic decision to prioritize his constitutional right to present a defense over the concern about personal embarrassment. That some of the text messages may have contained language or content that could have embarrassed Appellant Adelson does not make their exclusion proper. Appellant Adelson's willingness to risk personal embarrassment in order to present relevant exculpatory evidence underscores, not undermines, the legitimacy of his position. Footnote 6. As an aside, by way of connection, back to the doctrine of invited error, Appellant Adelson notes that had the exhibit been admitted and Appellant Adelson later complained on appeal that the messages embarrassed or prejudiced him because they're sexual, racist, or other offensive references, that argument would have amounted to invited error. End footnote 6. The trial court excluded evidence that Appellant Adelson affirmatively wanted the jury to see the support his defense. The trial court's exclusion of the text messages violated both the evidence code and Appellant Adelson's constitutional right to present a defense. The proffered texts were relevant to rebut the state's inference that communications between Appellant Adelson, Magbanua, and members of his family concerned the murder. See subsection 90.401 Florida statutes. Evidence is relevant if it tends to prove or disprove a material fact. The error undermines the confidence in the outcome of the trial and goes to the very foundation of the case. See Everett v. State. The state's assertion that the jury would have been unsurprised to learn that Adelson did not text about the plot to kill Markel also misses the evidentiary point. The jury's hypothetical lack of surprise at the absence of incriminating statements cannot render otherwise relevant and exculpatory evidence inadmissible. See subsection 90.401 Florida statutes. Moreover, the state cannot both imply that Appellant Adelson's communications, the chain of traffic of phone calls, supported its theory of guilt, and then argue that the actual content of communications between the same people is immaterial. Footnote 7. Defense counsel identified the inconsistency. Mr. Rashbaum, just for the record, in the state's case in chief, they were allowed to put in phone calls showing the arrows indicating that they have no idea anything said on these calls. They're essentially the same thing as putting in text messages like this, except you actually see the content, right? The court. The chain of the traffic versus what is actually said. Mr. Rashbaum, they put in every call. Okay, they put in every call between these participants on those particular dates, which, by the way, correspond mostly to the days that I'm offering these text messages for. They put them in for their own purposes. I think I should be allowed under a 403 analysis, what's good for the goose is good for the gander, to put in the text messages to show the pattern or lack of pattern of anything. But that's what these text messages show. But I can just ask the questions, but I would like the record to reflect that under a 403 analysis, it was allowed for them. It's not being allowed for us, the court. I wouldn't exactly say it boils down to being that simple, but your objection is noted, specifically as to what the state was permitted to demonstrate in their case in chief goes to either demonstrating motive or direct evidence of what they believe show the elements of the charges. As to these composite exhibits, and again, I don't want to get very deep into what the subject matter is, there are messages that either go to embarrassing of the other witnesses or litigants in this matter, matters that are wholly irrelevant, or matters that do not demonstrate in any way the theory of defense as the court understands it. If there are portions, again, that are specifically relevant to negating either the motive or any of the elements of the charges and are not hearsay as argued by the defense, I will consider those separately. but as a composite on the whole, the 403 issues, the relevance and hearsay issues, I believe, compel me to deny their admission. Mr. Rashbaum, thank you, Your Honor. End footnote 7. Once the state invited the jury to draw inferences from the existence and timing of those communications, fairness required that the defense be permitted to introduce the content to place the inferences in their proper context. Excluding the messages deprived the jury of the best and most direct evidence of what those communications truly were, i.e., ordinary, not conspiratorial. Finally, the state asserts that Appellant Adelson was not harmed by the exclusion of his proffered evidence because he testified about the text messages. Respectfully, Appellant Adelson does not share the state's view. A defendant's own testimony is no substitute for contemporaneous documentary evidence that objectively corroborates the theory of defense. Jurors could reasonably view a defendant's testimony as inherently self-interested, whereas the text messages themselves would have provided independent, contemporaneous proof of his state of mind and shown the ordinary, non-criminal nature of his communications to rebut the state's claims that Appellant Adelson was planning a murder with the people with whom he communicated. Further, Appellant Adelson's testimony was only a fraction of the evidence necessary to support the defense theory. The trial court's exclusion of the text messages, which would have provided some evidence that he regularly communicated with the so-called co-conspirators not about the murder, effectively left Appellant Adelson with no meaningful evidence to present to the jury in support of his defense. See Mateo. Such a decision is generally considered harmful error. See Zanichi v. State, finding exclusion of the defendant's only proffered evidence in support of his defense to be harmful error. The exclusion of the text messages evidence violated Appellant Adelson's fundamental right to present a complete defense and left the jury with an incomplete and misleading picture of the interactions at the heart of the case. The resulting prejudice was substantial. On one hand, the state was permitted to introduce a pattern of phone calls and argue to the jury, footnote 8. Significantly, the state emphasized this argument in its closing. Ms. Kappelman, the communication records tell us a few other things too. That's the June trip, July, June. This slide shows all the calls between our parties on the night before the shooters made that June trip to Tallahassee. You can see a 25-minute call from Catherine Magbonawa to the defendant at 9:17 p.m. on June 2nd, 2014. This call was placed while Catherine Magbonawa was consistent with traveling on her way back from Comfort Rental Car, where the first rental car was rented, to her residence. As soon as the defendant hangs up with Katie, he calls his parents' landline and has a 25-minute conversation. Continuing, on the day of the murder, we have communications between our parties, as listed here with the red line representing time of the murder. This flurry of calls between our persons of interest demonstrates the usual call pattern that we're seeing. Donna to the defendant, to Catherine Magbonawa, to Garcia, and back. Continuing, so we've got all this evidence that points to the defendant. The motive points to him. When we follow the money, it leads to him. The Prius eventually leads back to him through these conspirators, and each time we have a big event in this case, we see these call flurries where all the parties are calling each other in that structure that I had talked about. It goes from this one to this one to this one, but as the defense points out, these folks had independent relationship with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about the murder or if these call flurries around these key evidence are just a coincidence? A conspiracy can be shaped like a cluster with everybody talking to everybody. It can be shaped like a wheel with one central hub talking to all the different spokes, or it can be shaped like a train car, which is what we have here, where one person talks to only the person, the car in front of them, and the car behind them. End footnote 8. And argued to the jury that they reflected communities related to the murder. On the other hand, Appellant Adelson was precluded from rebutting that claim with direct evidence that would have done so. The error was not harmless. Florida appellate courts have consistently held that an error is not harmless when the evidence that is the subject of the error is highlighted or emphasized by the state during closing arguments. See Martinez v. State, quoting, "We cannot find the improper opinion of guilt testimony to be harmless beyond a reasonable doubt, especially when it was again highlighted in closing arguments," end quote. Allen v. State. The fact that the state emphasized this erroneously admitted evidence in its closing argument also may have tainted the validity of the jury's verdict. The improper exclusion of the text messages resulted in a violation of Appellant Adelson's constitutional right to a fair trial. See U.S. Constitution Amendments 5 and 14, Article 1, subsection 9, Florida Constitution. Appellant Adelson is therefore entitled to a new trial. 4. The trial court erred when it excluded evidence that was highly probative to the theory of defense, which was relevant and both non-hearsay and accepted from the hearsay rule, i.e., a recorded phone call from 2016 in which Appellant Adelson references a past extortion. As to Claim 4, Appellant Adelson continues to rely on the argument made in the initial brief. In its answer brief, the state argues that the excluded evidence was hearsay, not subject to a hearsay exception, and the exclusion did not prejudice Appellant Adelson. For the reasons set forth below, Appellant Adelson respectfully disagrees. The state's argument regarding hearsay rests on the mistaken premise that Appellant Adelson offered his statement, the phone call, and specifically the quote, "It's not done like that," for the truth of the matter asserted. The record demonstrates otherwise. The defense did not seek admission of the recorded phone call to prove that extortion generally occurs in a particular manner. Rather, the statement was offered to show Appellant Adelson's contemporaneous belief and state of mind, specifically that the people confronting his mother were not the same individuals who had previously extorted him following Dan Markel's murder. This belief directly supported the defense theory that Appellant Adelson was a prior victim of extortion related to the murder and not a participant in a conspiracy to carry it out. Section 90.803, paren 3 Florida statutes provides 3. Then existing mental, emotional, or physical condition. A statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health, when such evidence is offered to 1. Prove the declarant's state of mind, emotion, or physical sensation at that time, or at any other time when such state is an issue in the action. 2. Prove or explain acts of subsequent conduct of the declarant. B. However, this subsection does not make admissible 1. An after-the-fact statement of memory or belief to prove the fact remembered or believed unless such statement relates to the execution, revocation, identification, or terms of the declarant's will. 2. A statement made under circumstances that indicate its lack of trustworthiness. Subsection 90.803, paren 3 Florida statutes. As such, the offered evidence was an out-of-court statement offered to show Appellant Adelson's beliefs, impressions, and or reactions, and it is captured by Section 90.803 as a hearsay exception. Additionally, because the statement was not offered for the truth of the matter it asserted, it was not hearsay or non-hearsay. See Fields v. State. Utterances which circumstantially indicate a specific state of mind causing them do not constitute hearsay. Here, the defense explicitly explained that the statement was relevant to Appellant Adelson's belief, i.e. his mental state at the time of the bump, that law enforcement, not his prior extortionists, were behind the contact. This was a central factual dispute in the case because the state's theory was that no prior extortion ever occurred and that Appellant Adelson's payments were part of a murder-for-hire scheme. By contrast, Appellant Adelson maintained that his money reached the killers only because he was being extorted by them in the aftermath of the homicide. Because the statement was not offered for its truth, the hearsay rule does not apply. Footnote 9. The state argues that Appellant Adelson cannot raise a non-hearsay argument on appeal because at trial defense counsel relied on a hearsay exception, state of mind, to support admissibility. However, the trial court sustained the state's hearsay objection, ruling that the evidence was inadmissible as hearsay. Consequently, that ruling is properly reviewable by this court. It is clear from the record that the proffered evidence was not offered for the truth of the matter asserted, and as such is non-hearsay. The trial court's exclusion of the evidence as hearsay, pursuant to the state's hearsay objection, cannot be insulated from review as to whether it was hearsay to begin with, merely because defense counsel invoked a hearsay exception. A statement excluded as hearsay, that is non-hearsay, remains reviewable. Additionally, the trial court's focus on whether Appellant Adelson was qualified to opine on how extortion is done reflects a misunderstanding of the evidentiary purpose for which the evidence was offered. Appellant Adelson asserts that this court may review the trial court's determination on this matter. The statement was not being used as expert opinion or as factual assertion about extortion practices. Rather, it was offered to illuminate Appellant Adelson's subjective perception and state of mind at the time of the 2016 bump incident. Specifically, his belief that the people contacting his mother were not the same individuals who had previously extorted him. By insisting on a foundation for opinion evidence, the trial court conflated the admissibility standard for expert testimony with the much broader standard of evidence of a party's mental state, thereby erroneously excluding highly relevant testimony that bore directly on Appellant Adelson's defense theory. The trial court's mischaracterization of the statement as an opinion requiring qualification deprived the defense of the opportunity to present extemporaneous, corroborating evidence of Appellant Adelson's state of mind, which was both probative and material to a central issue at trial. End footnote 9. Alternatively, the statement qualified under the state of mind exception, subsection 90.803, paren 3, paren A, Florida statutes, as evidence of Appellant Adelson's then existing mental, feeling, or belief. The state argues that Adelson wanted to use his statement to show that he had been extorted in the past, but the state of mind exception to the hearsay rule only encompasses future conduct, not prior conduct. See Reed v. State. Appellant Adelson respectfully disagrees with the state's characterization. The proffered evidence was a contemporaneous expression of Appellant Adelson's belief as the events of the bump unfolded. Appellant Adelson's recorded words were made during the 2016 bump incident and therefore squarely fit within section 90.803, paren 3. Appellant Adelson agrees with the state that a hearsay statement which recounts observations made previously is by definition an after-the-fact statement of memory are expressly excluded from the state of mind exception. But that is not the circumstance here. Here, Appellant Adelson did not recount past events reflecting on what he previously thought or experienced, but instead made a contemporaneous expression of belief that law enforcement, not his prior extortionists, were behind the contact at the time of the bump occurred because of his past experiences with extortion. Nor was Appellant Adelson's attempting to use the state of mind exception to explore the state of mind intention or motive of anyone other than himself. The state asserts that Appellant Adelson attempted to offer the evidence to prove that Garcia or Magbanua extorted him. That characterization is also incorrect. Appellant Adelson's statement was offered solely to show his own contemporaneous beliefs and perceptions, specifically that he understood the individuals contacting his mother during the 2016 bump to be different from the people who had previously extorted him. The statement was therefore properly framed as evidence of Appellant Adelson's state of mind, not as evidence of another person's actions, intentions, or motives. But this observation is directly tied to the statement's role in supporting the defense because it captured appellant Adelson's immediate perception during the 2016 bump. The recording independently corroborated the defense theory that he had been previously extorted by Dan Markel's killers. Importantly, as explained above, the statement was not offered to prove that Garcia or Magbanawa actually extorted him. Rather, it was offered to show that in 2016, appellant Adelson made a contemporaneous statement acknowledging that he had been extorted. The timing is significant because it occurred many years before his arrest, long before any motive to fabricate, and thus it carried exceptionally evidential weight. Unlike testimony presented years later at trial, the recorded statement reflected appellant Adelson's contemporaneous understanding of events and lent credibility to his account. By excluding this evidence, the jury was left with only appellant Adelson's trial testimony without the benefit of a contemporaneous record affirming his claims. Footnote 10. Once again, the state highlighted this in closing, arguing that multiple times that there is no evidence of the extortion and that appellant Adelson made it up as a defense for trial. Mrs. Kappelman. He doesn't say, no, I have no general idea what you're talking about. He says, all right, he absolutely does have a general idea when she's talking about. And if they were innocent, as the defendant has claimed, and this was, in fact, a second extortion attempt, there is not a reason in the world why they wouldn't just say that. I got approached by another one. One came and paid me a visit today. It's happening again. That's crazy. That's his response. And I'm not adding the emphasis on that syllable. He says it like that. That's crazy. Why is it crazy? You're already being extorted by Latin King members. Remember, Doctor? It's because he hadn't come up with that part yet. Continuing. But at no point does he acknowledge the first extortion in the Dolce Vita meeting. Why? Why not? Oh, because she asked me not to talk about it. Well, times have changed. There's a second extortion effort now, and they're approaching my mother. You think I'm not going to mention the first extortion? Your people have been running their mouths, and now they've tracked down my mother. You need to get this under control. Nothing like that. Continuing. He's explaining to her that the problems with paying a potential extortionist. What he doesn't say, which is what you expect if he'd been getting extorted for 2 years, is Garcia or whoever you've been giving money to has obviously been running their mouths, and now they are messing with my mother. Continuing, the defendant hoping it's the police and saying, quote, these people only know part of the story or they think they know part of the story. The defense picks that out and says, oh, there he is talking about the first extortion. Or is he saying, why did they go to my mom instead of me? And footnote 10. Had the jury heard the statement, it would have materially influenced their evaluation of his credibility and the plausibility of the defense. This demonstrates that the erroneous exclusion of the evidence was highly prejudicial and undermined appellant Adelson's right to a fair trial. As in Claim 3, the error was not harmless because the subject of the error was highlighted and emphasized by the state during closing. See Martinez, Allen. Additionally, as in Claim 3, the fact that the appellant Adelson testified to the content of the excluded evidence did not render its exclusion harmless because appellant Adelson's own testimony is no substitute for contemporaneous documentary evidence that objectively corroborates the theory of defense. Jurors could reasonably view a defendant's testimony as inherently self-interested, whereas the recording itself would have provided independent, contemporaneous proof of his state of mind, and shown that in 2016, long before his arrest for these offenses, appellant Adelson made a statement indicating a previous extortion. This would have rebutted the state's claims that appellant Adelson made up the extortion defense, which was a theme during closing argument. The state makes an additional argument, specifically that other phone calls between Adelson, Magbanawa, and Garcia disproved Adelson's story about being extorted. This argument does not engage with the critical evidentiary considerations at issue. The existence of contrary evidence in the record does not render otherwise admissible evidence inadmissible. Evidence that supports a party's theory is not negated, and its exclusion is not harmless simply because other evidence might appear inconsistent or contradictory. Rather, it is the jury's role to weigh conflicting evidence and assess credibility. Moreover, the exclusion of Appellant Adelson's contemporaneous statement in the face of admitted evidence that could be interpreted against him actually exacerbates the prejudice. By denying the jury access to the 2016 recording at issue while allowing other calls to be admitted, the trial court deprived the defense of an important tool to corroborate the theory of defense with Appellant Adelson's perception at the time to allow the jury to fully evaluate the credibility and plausibility of his account. In other words, the exclusion did not merely prevent repetition of evidence, it eliminated uniquely probative, corroborating testimony that was essential to the defense theory. Accordingly, for the reasons set forth above, the trial court erred by excluding Appellant Adelson's statement from the 2016 recorded phone call. The improper exclusion of the call resulted in a violation of Appellant Adelson's constitutional right to a fair trial, see U.S. Constitutional Amendments 5 and 14, Article 1, Subsection 9, Florida Constitution. Appellant Adelson is therefore entitled to a new trial. 5. The errors cumulatively in this case denied Appellant Adelson his constitutional right to a fair trial. Appellant Adelson asserts that, in light of the errors set forth above, he was denied his constitutional right to a fair trial. See U.S. Constitutional Amendments 5 and 14, Article 1, Subsection 9, Florida Constitution. The state's contention that Appellant Adelson's cumulative error claim fails because his individual claims are allegedly procedurally barred, meritless, or both, misinterprets the nature and impact of the errors. Claims 1 and 2 cumulatively affected Appellant Adelson's right to a fair trial and impartial jury in violation of both the United States Constitution and the Florida Constitution. Claim 1 demonstrates that the trial court erred by denying Appellant Adelson's motion for a change of venue despite pervasive community-wide pretrial publicity and a venire saturated with preconceived opinions of guilt. Claim 2 shows that the trial court compounded this error by refusing to strike the venire panel after multiple prospective jurors engaged in discussions about the case in violation of explicit court instructions. Taken together, these errors materially undermined the fairness of the trial because not only was the jury drawn from a prejudiced community, but that prejudice was actively reinforced through juror misconduct that went unremedied. The cumulative effect of these errors deprived Appellant Adelson of the constitutional guarantees of due process and trial by an impartial jury. And the evidentiary errors explained in Claims 3 and 4 cumulatively deprived Appellant Adelson of critical evidence central to his defense. The exclusion of the composite text message exhibit prevented the jury from seeing that communications between Appellant Adelson and the alleged co-conspirators during the relevant period were ordinary, non-criminal exchanges directly contradicting the state's theory that contemporaneous phone activity reflected conspiracy, solicitation, and coordination to carry out the murder. Simultaneously, the trial court's exclusion of the recorded 2016 phone call barred the jury from hearing Appellant Adelson's contemporaneous expression of belief that the people confronting his mother were not the same individuals who had previously extorted him following Dan Markel's murder. Together, these rulings silenced the most direct, contemporaneous evidence of Appellant Adelson's state of mind, leaving the jury with only selective inferences and post hoc testimony that could be viewed as self-serving. These errors went to the heart of the defense, undercutting Appellant Adelson's ability to challenge the state's narrative and to present a complete and constitutionally adequate defense particularly because the state capitalized on the errors and relied on the evidentiary gaps in its closing argument, asserting both that, 1, the pattern of phone calls that it was permitted to introduce demonstrated that the alleged co-conspirators were actively planning and discussing the murder, and the excluded text messages would have rebutted this, and 2, appellant Adelson's testimony about prior extortion was fabricated for trial, and the excluded phone call would have provided 2016 evidence mentioning appellant Adelson's state of mind relative to the extortion defense. By holding appellant Adelson's trial in a venue permeated with pretrial publicity and community bias, requiring jury selection from a pool influenced by those biases, and excluding both the composite text messages demonstrating ordinary non-criminal communications to rebut the state's evidence and the contemporaneous recording statement reflecting appellant Adelson's state of mind relevant to the defense and long before he would have needed to come up with the extortion defense, the trial court deprived appellant Adelson of a fair opportunity to present his defense, which undermines confidence in the outcome. Appellant Adelson asserts each of these errors, standing alone, rises to the level of reversible error. But if the court determines otherwise, then certainly the cumulative effect of the errors denied appellant Adelson a fair and impartial trial. See Broomfield v. State, citing Slagle v. State. Conclusion. Accordingly, for the reasons set forth above and contained in the initial brief, the appropriate remedy for all claims is a reversal of appellant Adelson's convictions and a remand with directions that the trial court conduct a new trial. Signed, Michael Ufferman, Laurel Cornell Niles.